Alright, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Brothers and sisters, our program will begin shortly after this. So in the meantime, you can call all of your friends to join our program today. Inshallah, may we benefit from this program today. So we will begin maybe in several minutes. Thank you. Alright, so Bismillahirrahmanirrahim. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Greetings to our amazing speakers, Sister Nur Shahmina binti Zainal Abidin, Brother Muhammad Ashraf Hakimi bin Zaid, Brother Muhammad Khairil Anwar bin Muhammad, Head of Department of Legal Studies, Madam Fariza binti Abdul Jalal Bakri, MILEX Advisor, Sir Muhammad Ridwan bin Saleh, lecturers from Legal Studies Department, members of MILEX Shura Council, organizing committee for this program, and my beloved friends. So Assalamualaikum warahmatullahi wabarakatuh, and a very good morning I bid to all of you. Thank you to the Almighty Allah subhanahu wa ta'ala. With his blessings, we are given the opportunity to be here today in this program. So for your information, I am Nurul Batrisha binti Norizan, and I will be the moderator for our program today. Now we will start off by singing the national anthem, Asma'ul Husna, and IIUM song.
نسألك يا من هو الله الذي لا إله إلا هو الرحمن الرحيم الملك القدوس السلام المؤمن المهيمن العزيز الجبار المتكبر الخالق البارئ المصور الغفار القهار الوهاب الرزاق الفتاح العليم القابض الباسط الخافض الرافع المعز المذل السميع البصير المقيت الحسيب الجليل الكريم الرقيب المجيب الواسع الحكيم الودود المجيد الباعث الشهيد الحق الوكيل القوي المتين الولي الحميد المحسن المبدع المعيد المحيي المميت الحي القيوم الواجد الماجد الواحد الصمد القادر المقتدر المقدم المؤخر الأول الآخر الظاهر الباطن الوالي المتعالي البار التواب المنتكم العفو الرؤوف مالك الملك ذو الجلال والإكرام المقسط الجامع الغني المغني المانع الضار النافع النور الهادي البديع الباقي الوارث الرشيد الصبور الذي ليس كمثله شيء وهو السميع البصير اللهم صل أفضل الصلاة على أسعد المخلوقات كسيدنا محمد وعلى آله وصحبه وسلم عدد معلوماتك ومداد كلماتك كلما ذكرك ذاكرون وغفل عن ذكره الغافلون.
Let's lead the way, enlighten the future, share the wisdom to the spirit of Islam. Revelation and reason, we shall excel, we shall prevail. Merging faith and knowledge, we the Khalifa, we will fulfill the Amal.
All right, so before we start our program, I would like now to invite Brother Ahmad Ziad Abqari bin Ayub to lead the Dua recitation. Please welcome.
Test. Am I audible? Is my voice clear?
Yes, you are.
Okay. So everyone, please be ready for the dua recitation. أعوذ بالله من الشيطان الرجيم.
Brother Ziad, I think your mic is muted.
Okay, sorry. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين وعلى آله وصحبه أجمعين. Ya Allah, Ya Fa'al lima yurid, we express our gratitude to you for allowing us to attend this event on this auspicious day. O Allah, we ask you for the safety of our religion and the welfare of our body. O Allah, Lord of the implementing authority, make the days that we've gone through, starting with your mercy, continue with your blessing and righteous guidance, and end it with thy forgiveness. Make the days that we've gone through spent in your obedience, adorn us with the adornments of the righteous, and clothe us with the ornaments of the pious, in spreading good behavior, lowering the wing of humility, beauty of conduct, advancing towards excellence, avoiding condemnation, being gracious to the undeserving, and speaking truth though bitter. Ya Allah, Ya Muhaimin, Ya Aziz, Ya Jabbar, let our efforts as a means to enlighten and convince ourselves that the personal safety of either outer or inner is a prerequisite for achieving happiness and excellence in various fields. O Allah, grant us faith and strength in order to face the challenges of life during these needy yet troubling times and in the face of life in this new norm. Ya Allah, Ya Farij al-Ham, Ya Kashif al-Gham, Ya Man li'abadihi yaghfir wa yarham. O Allah, show us guidance and adjust our path and ways to achieve happiness and glory. Let us listen to people who like the good things and let us avoid doing the bad and evil things. O Allah, bless our life in this gathering and prevent us from harm and unfortunate events. Prevent us from harm and unfortunate events. Prevent us from harm and unfortunate events. ومكروا ومكر الله والله خير الماكرين. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين.
Amin, Amin, Ya Rabbal Alameen. Thank you, Brother Ahmad Ziad Abqari bin Ayub, for the Dua recitation just now. It is hoped that our program will be in his blessing, inshallah. So for the flow of the program, I will brief a little bit about the flow of the program. We will start off with the introduction of the speakers. So after having 3 different slides by 3 different speakers, and lastly, we'll have a Q&A session. So all of you can prepare your questions if there are any. So if you have any questions during the session, you may ask them in the chat box, and inshallah, at the end of the session, the speakers will answer them. Next, I would like to introduce all of you to our 3 lovely speakers for today. So our first gorgeous speaker is Sister Nur Shahmina binti Zainal Abidin. She is a 3rd-year student, Bachelor of Laws at International Islamic University, Malaysia, Gombak, IIUM. And she's also an active oralist participating in various oratory and mooting. And also was appointed as the student ambassador for KLBC Young Lawyers Committee to connect law students from IIUM with the legal fraternity from KL Bar Committee. And currently she serves as the president of IIUM Moots and Client Consultation Club. So next, our second speaker is Brother Muhammad Ashraf Hakimi bin Zaid. He is a 3rd-year student of ICOL, Ahmad Ibrahim Kuliah of Laws, and currently he was appointed as Vice President of the Secretariat Academic Law Student Society, International Islamic University, Malaysia, and is also active in mooting competitions. And last but not least, our third speaker is Brother Muhammad Khairil Anwar bin Muhammad. He studies at IIUM with a Bachelor of Laws, minor in Applied Finance, and currently was appointed as Vice President for Client Consultation of IIUM and Client Consultation Club, and is also active in Mooting competition. So thank you so much to all speakers who willingly accepted this invitation. So I'm sure that everyone must be so excited for the first slot. So without further ado, I would like to invite our tremendous speaker today, Sister Nur Shamina binti Zainal Abidin, to share her knowledge about Mooting. So the floor is yours.
Thank you, Sister Nurul Batrisha. Before I start, may I know if I'm audible?
Yes, you are.
All right, so I'll start presenting my slide first. All right, can you guys see my screen now?
Yes, we can.
Okay. All right. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And a very good morning, I bid to my fellow brothers and sisters, and also if they're Sir Ridwan, and also the advisor for Lex. So before I proceed with this session of introduction to Mooting, I think it will be better for me to introduce myself once more again, and also to talk about my participation in past Moot competition, and together with the accomplishment, and also what are the lessons or the things that I've gotten throughout my participation in Mooting. So my name is Nur Shamina binti Zainal Abidin. I prefer to be called as Mina, M-I-N-A, because it's much more short, sweeter, and concise that way. So I'm currently in my third year, second semester, and pursuing in LLB. I'm not a Sharia student, unlike Brother Ashraf. Brother Ashraf is a Sharia student. Also, I'm currently serving as the president of IIUM Moots and Client Consultation Club for the tenure of 2022. And speaking about my participation in Mooting, I had actually first participated in Mooting since I was in my first semester. So it's been like 2 years getting involved in Mooting altogether. And the first Moot competition that I entered into, it's called the Kuala Lumpur Pre-Moot competition. And at that time, I know nothing about Mooting, just like you guys, because when I was in CFS, there was no exposure about what is Mooting, client consultation, or law students competition at all. So only when I entered into Gombak, even when I entered into Gombak when I was in my first year, there was still no exposure about what is Mooting. It's just a matter of getting viral message from WhatsApp, knowing that there is a selection. And since at that time, I was actually pretty much being excited about being in oratory-based competitions, because I've always been interested in talking and speaking to people as general. So I just tried out for this selection for that KL Pre-Moot, and I was selected as a researcher. So at that time, we have the position for oralist and also researcher in the team. But I was not selected as the oralist because my marks is a bit low compared to the one that was selected for oralist, but it's okay. I just tried out for the researcher. So that were like a lot of things that I learned, of course, from my seniors, like how to do research, what are the laws that I should discover, or I should have used when using my research, and how to actually write a written submission. That is what I've learned. And however, we did not go to the actual competition for KL Pre-Moot because at that time there was COVID. It was early 2020. So since we withdrew from KL Pre-Moot, I tried out for the second competition, the Moot competition. It's called the NAMCO, or the full name of NAMCO is Novice Arbitration Mooting Competition. So it's actually a type of Moot competition that is catered for novice mooters, the first time mooters who did not have any experience in mooting. So we are welcoming this kind of students, especially from first year, second year, even third year, who had no experience in mooting, to join this novice arbitration mooting competition, NAMCO. So because at that time, my passion in mooting has escalated. So I was very, very desperate to join NAMCO. So I just tried out the selection, and it turned out to be like there were a lot of participants trying out for NAMCO. And at that time, I tried out NAMCO with Brother Ashraf, and both of us were selected as the oralists for the team. But I was in team 1 and Brother Ashraf was in team 2. So Alhamdulillah, despite being in the first trying out the NAMCO for the first time, my team came out as a champion for that competition, NAMCO. And in fact, that was the very first time IIUM had won that competition, in particular NAMCO, since it started in 2010. So that was, Alhamdulillah, a great accomplishment for a startup like this. And then that was my second Moot competition. And right after that, because I have never gotten tired of getting involved in mooting, I don't know like why I'm so addicted to mooting. So I entered into the third mooting competition, which was also in the year 2020, the same year as NAMCO. It's called the VIS Commercial Arbitration Mooting Competition. So VIS Commercial Arbitration Mooting Competition, or also known as LexMoot, is actually the largest mooting competition in the world for law school. It's for the arbitration setting. So what's the difference between the moot court, mooting competition, and also arbitration mooting competition? I would be explaining them later, details in my presentation, but so far this is what I want to say. So at that time, I just tried out and I got selected as the oralist for this moot. And then also around that time, we came out as the champion for the AIAC pre-moot. So basically what's the concept or the how this moot work is that since it's the largest mooting competition in the world among law school around the world, so we have like a series of pre-moot competition. So pre-moot serve as a training for moot, for the actual moot, but it's set in the competition settings. So we came out as a champion for best Malaysian team at that time. Alhamdulillah once again. And then since I've never stopped, I've never gotten tired again, I was appointed right after moot ended. I was offered to be a coach for the sports arbitration mooting competition team for IIM team. And then we, Alhamdulillah, we came out as we managed to advance up to semi-final for SAMCO. So it's a sports arbitration, sports law basically. And then last but not least, it's not last but not least, I'm not sure if I want to join mooting again in my final year or not, but right after SAMCO ended, like a few months gap, I joined the VIS Commercial Arbitration Mooting Competition, which had ended last April 2022, sorry. But we didn't win any awards for that competition, but it's still a great experience. So that is what I participated so far in Moot competition. I would say that I'm a truly experienced or what. It's just a matter of me keeping on learning what mooting serves. That is what I have learned so far. And in regards with what are the things that I've gotten throughout my participation in mooting, first and foremost would be about it boosts my confidence, because before this, it's not to say that I was insecure speaking or not having confidence, but it's just a matter of presenting myself better. Because when you go into law school, especially when you are entering your degree life in ICOL, you would have so many presentations. Like almost every single day, you are required to speak in your tutorials, with your classmates, with your lecturers, even in classes you have to present. So it actually boosts your confidence. That is the first thing. And the second things that I've gotten throughout my participation in mooting is that it changed how I view the law, because it is not confined to the academic studies when it comes to law, but it goes beyond that. It actually helps me a lot in answering my examinations. Like I do not see the questions in one aspect or one angle only. It actually helps to extend me to my knowledge, and also how do I want to write in my examination, also in my presentation. So because mooting requires a lot of research and in-depth research. So when you are going into mooting, you actually are applying all the things that you have learned in mooting in your studies, which also actually helps a lot. And also, I've gotten like a plenty of connections from various law school students who participated in mooting, the mooters. So until now, even though like most of the competitions have ended, but we still maintain a good relationship with one another. And also last but not least, one thing that I treasured a lot when it comes to mooting is the memories with teammates. Because when you go for mooting competition, you are actually spending a lot of time together with your teammates for a very long time. Even when I go for LexMoot, the preparation time took around 7 months. And throughout that 7 months, I am spending my time with my teammates, preparing for the oral submission, preparing for the written submission. Together we train, we do research together. So that amount of time actually helps you gain a lot of friends and helps you to strengthen the friendships that you had with a group of people that you will never know you will have connection with. So that is the most memorable part of the meeting. So it actually extends to a lot of aspects, what I see. All right, so having done with a little bit of introduction about myself, now we will be going into details with what is mooting or introduction to mooting. All right, before I start, can I know that is my slide changing now?
Yes, it is.
All right, thank you. Okay, so what is mooting? I've been babbling for the past few minutes. What is mooting, mooting competition, arbitration, and what are those stuffs? So basically, when we talk about mooting, what is mooting is that mooting is actually a simulation, also known as a curricular activity for law students around the world, whether you're in Malaysia, Australia, or even in UK. Law students are supposed to know what is mooting because it is not only it is basically a curricular activity, but it also extends to your academic syllabus of studies as well. So it's actually a simulation of a court hearing in which participants will analyze a problem, research the relevant law, prepare written submissions, and present oral argument. So it's basically like how you see in drama, in legal K-drama, like how there is a counsel and also parties, as disputing parties will be presenting your case before a judge. So that's basically what mooting is. It's basically a trial or a court hearing. So in mooting or also mooting, basically it's mooting, there are actually two settings of mooting, which I have mentioned. Firstly, it's in the moot court setting, and secondly, it's in the arbitration setting. So moot court, what we have familiarized ourselves with ever since we are in CFS studies would be the moot court setting, which you would be representing your client to present your case before a judge. That is how mooting works. And on the other hand, as opposed to moot court settings, we have the arbitration settings. Now, arbitration, what is arbitration? Is that arbitration is a form of ADR, alternative dispute resolution, in which it is type of settlement outside of court. If moot court is inside the court, arbitration is outside the court. But still, it requires your client to be represented by counsel, which is you, and also a matter to be presented or a dispute to be presented before the judge. But in arbitration setting, we do not call the judge as the judge. We call them as the arbitrator because they do not have the qualification as the judge. So that is why we do not call them as judge, Yang Arif or Your Honor. That's basically a little bit of general difference between moot court and arbitration settings when it comes to mooting. So when you join moot competition or even when you are preparing for your assignment for mooting, there are a few stages that you have to observe. First is when you are given the moot problem. So the moot problem is the written form of the disputes that you have to settle for your client. So that is called the moot problem. So in the moot problem, you have to analyze what exactly is the problem, what is the dispute, what does your client want, or what is the disputing parties is talking about, who breached a contract, if there is a contract, and what are the remedies that your client wants. So that's basically you have to analyze in that problem. And then after that, you would have to construct an arguments for your clients to be presented for the hearing later on. And then throughout that period of constructing your argument, you would also have to research the relevant law. So for example, the area of law or that your moot competition is based on is contract law. So in doing so, in constructing the argument based on the contract law, you would have to find in the problem, is there any contract between the parties that have been concluded, or is there any contractual relationship between the parties, and who breached the terms of the contract, who breached the conditions of the contract. And in doing so, what is the relevant law to be applicable? So the relevant law to be applicable in contract law, usually we will be using the Contract Act 1950. If it is in the local setting, if you go for a local mooting competition. And if it is the international setting, then you will have a different set of law. Usually it's called the CISG, Convention of United Nations Sale and Goods. So basically that is the relevant law that you have to apply, because when we talk about argument, there can be two types of argument: factual argument and also legal argument. So these two types of argument would go together, would work side by side. You cannot just present your factual argument without supporting that argument with your legal basis, such as from the statutes, the case laws, or even the journals. So these are the laws, the primary sources, and also the secondary sources of your laws that you should apply in constructing your argument. So right after that, you would be preparing your written submission. So what is written submission? It's basically a document where you present all your arguments in a format that has been stipulated by the organizer of the moot competition, or even the mooting rules and regulations that is set up by your lecturer if you are doing your assignment lah. So this written submission will consist of the arguments for both sides. So for example, if you are representing the claimant, so you would have to write arguments to defend your client as to why your client's argument should be accepted by the judge, or why your client is correct in this case, and why the opposing side is wrong, has erred in law in applying that arguments or whatsoever. So firstly, usually in mooting competition and also in assignments, you would have to prepare for both sides, for both claimant and also respondent, for example. So the first period of time, for example, in 1 month after the mooting competition has commenced, you will be given time to prepare your written submission on behalf of the claimant first. So you will then prepare, research all the relevant laws to prepare for the written submission for claimant. And after that, you will submit that written submission to the organizer if you are going for mooting competition, or to your lecturer if you are doing your assignment. And after that, after doing the written submission for your claimant, and then you will be switching side to the respondent. And after that, you will have to prepare a written submission for the respondent. So you have to prepare for both sides. So you have to think like what to think if you are representing as a claimant, and what to think if you are representing the respondent. So it really requires an in-depth research, a detailed research, so that you manage to present the best arguments for your clients to be presented by your judge. So this is the written submission phase. And right after written submissions ended, you would now prepare for the oral argument or the oral submission. Now this is where the court hearing or the arbitration hearing will set in. So you will have a specific date to present your case before the judge or even the arbitrator. So before that set date is materialized, you will have to train for your oral argument. So this is where that written submission arguments would have to be materialized into your oral argument. But of course, you cannot read whatever that has been stated in your written submissions to the court. That's not how it works. The written submissions will be the detailed one, while the oral argument is more like a summary, or like the important part of your written submission. You will have to select the best points from your written submissions to be presented orally before the judge. So basically, whatever that you write in your written submission will not be 100% automatically transferred into the oral argument. You have to select which one is the best, which one is the strongest point, and which one is the most confident point that you want to bring out during the hearing. So basically, what I can say is there are 3 stages when it comes to mooting. Firstly is analyzing the problem, research relevant law, and then secondly is preparing your written submission, and lastly is presenting the oral submission before the judge on behalf of your client. So the duration of these phases would actually vary from one phase to another phase. The most, or I would say the longest phase, would be the research phase, because you would have to prepare a lot. You will have to prepare the arguments, you will have to prepare the laws, and also the possibility of getting stuck in your research, because you just don't know where to start, you just don't know where to proceed from this point to that point. So that is why the research phase is the longest phase. And written submissions is pretty long phase as well, because it is also included in the research phase. But oral phase, oral argument, presenting or training for your oral argument will be the shortest phase, because basically at this point of time you already know what you are having in your mind right now. It's just a matter of materializing it in form of oral submission. So that would be the stages of mooting in general. So as I mentioned earlier, the opposing pairs of counsel will argue a fictitious legal case in front of a judge. So fictitious legal case means that the moot problem that you are receiving is basically a type of or an area of law or even a dispute that has not yet been settled, and it has never been in existence. Because this is very important to know, because if that dispute has already been disputed, or there is already a decision for that dispute, there will not be a mooting. It's not called mooting. Mooting is when you are obtaining a fictitious legal case or a legal dispute that has never occurred in real life before for you to settle on. And these decisions or outcome of your research or whatever you have presented before the judge can actually be used by the lawyers if, let's say, in the future there is a similar dispute that is going on. And this is happening if you are going for a big mooting competition, for example, the BIS commercial arbitration mooting competition. So the moot problems that you are obtaining is actually the one that the organizer or the few selected countries of a working draft paper or whatever it is, they are having that kind of dispute at that time, and they require you to research for that so that they have a set of laws to follow. So it seems like a win-win situation for them as the organizer, and also for us to learn in the future. So that's basically a big mooting competition would usually offer to the law students, basically. So to win, you do not necessarily have to win the legal case, but you must make the best presentation of your legal arguments. So because in mooting competition, in whether it is a moot court setting or even arbitration settings, you would usually have to represent both claimant and respondent, because you are not, because the reason being is because we want to expand on, we want to show how does it feel like to represent the client in forms of the claimant or even the respondent. So to win, you do not have to win the legal case. For example, if you are representing your client for claimant, so this means that the claimant will win, or it is definitely a rule of default where your client is in the right and the opposing client is not in the right, is in wrong, or whatever it is. But it's just a matter of how you would present the best presentation of your legal argument. So it doesn't matter like who is in the right position in law and who has erred in law. It's just a matter of how you make sure that you will be presenting your legal arguments, be it for any sides of it. So here, the counsel, as you can see from the slides, it's either the plaintiff and defendant, or claimant and the respondent, or also appellant and respondent. So appellant and respondent is usually in the appeal case lah. Basically, mooting competition will focus more on the civil area of law compared to the criminal area of law. For criminal, we have other type of competitions. For example, the mock trial. So mock trial is not a form of mooting competition. It's other type of competition which is outside of mooting scope. So what I will be focusing right now is only on the mooting side, which focus on the civil law. All right, so next slide. Okay, so as I have generally just briefed about what is the difference between arbitration and moot court when it comes to mooting, is that for arbitration, the concept is that based on party autonomy, freedom of party to choose who gets to judge your case. That's basically the concept of arbitration. So in arbitration, a neutral person is appointed by the disputing parties to become the arbitrator to settle the dispute. So here, what you must take note is that, as I mentioned earlier, there are two opposing parties, the claimant and also the respondent. So this claimant will first appoint a neutral person to be appointed as the arbitrator. Okay, so it is an arbitrator appointed by the claimant. That is the first arbitrator. And the second disputing parties, which is the respondent, they would be also appointing their own neutral person to be appointed as the second arbitrator. So the second arbitrator would be an arbitrator appointed by the respondent. So these two arbitrators later will appoint the third arbitrator. So this third arbitrator is the Mr. President, or the presiding arbitrator, the one that is leading these three arbitrators. And these three arbitrators will make up the arbitral tribunal, or the panel of arbitrators. And these three panel of arbitrators will be settling the dispute between these parties. So it's basically a neutral person. That is the concept of the judges or the panel of arbitrators for the arbitration setting. So as opposed to the arbitration setting, we have the moot court setting. So as you know, in moot court, we have the judge, where parties do not have the opportunity to choose a judge to preside and adjudicate the dispute. So whether you like the judge or not, whether you are fond of that judge or not, or whether you hate the judge or not, you would have to still present your case before the judge, because you do not have the freedom between the disputing parties to actually choose a judge to adjudicate your disputes. And then the next fine difference is that when it comes to the structure or the formalities where you're presenting your case. So as for arbitration setting, the counsels or the disputing parties would be sitting down during the oral submission. So if you see in the legal drama, usually there would be a lawyer like standing and will be presenting your case in the middle of the court. And also, if you also see like the dramatic part of the legal dramas, where the lawyer would be like jalan-jalan here and there, you know, feeling something like that. But it's not allowed actually in real life. So that is for moot court. But arbitration, the counsels would be sitting down during the oral submission. I would be showing the picture of how the session for arbitration and moot court session after this. And also for moot court, as I've mentioned earlier, the counsel for disputing parties are standing up during the oral submission. And then the next difference would be in terms of addressing your judges. So in arbitration setting, you would be addressing your judges or the arbitrator as Mr. Arbitrator, Madam Arbitrator. And as for the presiding arbitrator, you would call him or her as Mr. President or Madam President. So the number of arbitrator when they are arbitrating the moot court, the mooting competition for arbitration session would have 3 maximum, and we have a minimum of 1. But usually there will be no 2 arbitrators, because we need an odd number to decide whether your team would win or not. And as for moot court, you can see we would be addressing our judge as either my lordship or my ladyship. So lordship is for male, ladyship is for female. And also it's between, also we can address them as my lord or my lady. And also the, if it's gender neutral, then we call them as young Arif, despite being a female or male judge. And also next, when it comes to counsel, we call our counsel as counsel and co-counsel. However, for moot court, we have senior counsel and junior counsel. So senior counsel would be submitting their argument first, followed by the junior counsel. So what I can deduce the difference between arbitration and moot court is that there is no really a huge or massive difference between arbitration and moot court. It's just a matter of formalities and the concept of freedom of parties in choosing who gets to adjudicate your dispute. So there's not really a massive dispute. It's just a matter of maybe in moot court setting, the area of law that is available for moot court competition would be different from the area of law that is offered for arbitration. Because usually arbitration is more on the commercial side. So we have the commercial law or even the construction law. So these 2 types of law is more prone of having the arbitration mooting competition. On the other hand, the moot court usually will have the constitutional law, tort law, contract law can also is available for moot court. So it's just a matter of what are the area of laws that are offered by these 2 types of competition, and also the formalities during the oral submission. All right. Okay, so I hope you can see the picture clearly. This is the picture of how the arbitration session is conducted. So as you can see, everyone is sitting down. No one is standing before the panel of arbitrators to present your oral argument. So on the left side, we have the counsels for respondent, And on the right side, we have the councils for claimant. And these three, the middle, in the middle of your screen, they are the panel arbitrators. And the one sitting in the middle is the presiding arbitrator, which is the Mr. President. So they would be giving out the oral argument. So usually we will start off with the claimant side for the first counsel and the second counsel. And after that, we will be following up with the respondent counsel 1 and respondent counsel 2. And then they will be having a rebuttal. So rebuttal is when you rebut what your opposing counsel has been saying about the argument. So that would be, the rebuttal will be first made by the counsel for claimant. And in response to rebuttal, we have the sir rebuttal. So this sir rebuttal is presented by the respondent. So basically whatever that has been submitted during the rebuttal session by the claimant, the respondent will rebut. So it's a matter of being very flexible, what I would say. And also these three arbitrators, during your oral submission, they would not be sitting still like how a presentation in your classroom works. Like usually the lecturers will ask you at the end of the presentation, right? But not when it comes to mooting competition. These arbitrators would be an active arbitrators. They will keep on questioning you during the oral submission. So you have to be flexible between submitting your point and also catering and answering your questions. So usually it requires you to be very adaptable with questions, be very flexible with questions, and also to always assist the tribunals in presenting your arguments. So this is the arbitration session settings. And also next, we have the moot court settings, the picture for moot court. So as I've mentioned earlier, it's just a matter of standing up or sitting down. So this counsel, who is standing up, is currently presenting his argument in front of the judges. So there's actually 3 judges, but you cannot see the presiding judges, of course, in the middle. So these two, the part, we have the on my left side will be the counsel for the respondent, and also on the right side we have the counsel for claimant, and the one that is standing would be anyone from either the respondent side or even the claimant side to present his argument when standing up in front of the judges. And there are 3 judges, so it's basically very similar to how arbitration works and also moot court works. It's a matter of structure, it's a matter of turn of the oralists, turn of the speakers, and of the counsels to present your argument. So there's not really much different, it's just similar. All right, so here are the moot court competition that so far IIUM or ICOR has sent our teams. So first we have the Taylor's InterVarsity Mooting Competition, the IVC. So this Taylor's InterVarsity Mooting Competition is actually a mooting competition, focuses on the contract law. The area of law is the contract law, organized by the Taylor's University. So for this year, our team, we have sent 2 teams, and one of the team has managed to advance up to semi-final. And our oralists as well has secured the top 10 of the best oralists. And I think the highest ranking was in the 4th rank out of the 15 plus oralists at that time. And also the second moot competition that we have also entered this year is the KPUM Extern Delamore E-Moot Court Competition. So KPUM is Kesatuan Pelajar Undang-Undang UK Malaysia, and they are collaborating with a legal firm, Shern Delamore. Shern Delamore is a legal firm. They are conducting a moot competition. The area of law is the tort law. And we have also sent 2 teams for this competition, KPM Shern Delamore E-Moot Court Competition. And also next, we have the KL Bar E-Moot Court Competition. So KL Bar E-Moot Court Competition is actually a competition which is very famous because it was actually organized by the KL Bar, KL Bar, basically it's a competition organized by KL Bar. And also the area of law focuses on the constitutional law, and we have been sending our teams every year because this competition has been in the mooting area for so many years. I don't remember like for how many years, but it's quite so long. And the highest accomplishment that we have accomplished in this mooting competition, Constitutional Law of KL-Bar, is we managed to advance up to semi-final as well for last year teams. So this year we would also be having this competition, inshallah, by this October. And also next we have the Red Cross International Humanitarian Law Moot Court Competition, or also known as the IHL Moot. So this area of law, as you can see, is the international humanitarian law, which is also the public international law. And what amazes about this IHL Moot competition is that our team, our IIM team, has came out as a champion for this Moot competition in the national level back in January. So it's actually a type of international humanitarian law, because moot court competition, they actually favor this kind of area of law: international humanitarian law, constitutional law, public international law. So this kind of area of law is very usual to see inside of moot court competition. And also the next mooting competition that we have entered is the Tun Sufyan Moot Court Competition. So Tun Sufyan Moot Court Competition, the area of law is also constitutional law, which was organized by the University Malaya. So last year we had also sent out teams for Tun Sufyan Moot Court Competition, and we also managed to advance up to semi-final. And aside from that, we won the best written submission. And lastly, this is not really what I would say a last moot competition. There is also other plenty of moot court competitions that we have sent, that we have participated, but this is just like a general idea of moot court competition that I would like to showcase today. So the next moot court competition, the Philip C. Jessup International Law Moot Court Competition. So Philip C. Jessup International Law Moot Court Competition is the biggest moot court competition in the world for law students. So law students from all over the world, be it from Malaysia, Indonesia, UK, US, the civil law country, the common law country, they can participate in this Philip C. Jessup International Law Moot Court Competition, also known as the Jessup. So the area of law is the International Law Moot Court Competition. So we had also sent out teams for this Jessup earlier this year, and they managed to advance up to the semi-final of the national round, and our speakers, our oralists, have managed to secure in the top 10 best oralists general rounds. And one of our speakers, Sister Inshirah binti Amim, the seniors, won the best oralist for this competition in the national round. So this is the few of the moot court competitions that we have participated. Okay, next we have also participated and sent teams for the arbitration mooting competition. So the one that I've mentioned, we have the novice arbitration mooting competition. So the highest accomplishment that we managed to secure for this competition is being the champion in the year 2020. And also the next, novice arbitration mooting competition, the area of law is the commercial arbitration, the contract law. And also the second arbitration mooting competition that we have also sent out teams to is the Law Asia International Moot Competition. So Law Asia also has the same area of law, such for NAMCO, the commercial arbitration, which focus on the contract and the dispute resolution, the alternative dispute resolution, ADR. And also next, we have the Saudi Center for Commercial Arbitration Arabic Moot. So this is the Arabic mooting, which if you are pursuing for the LLBS, then you have the opportunity to moot in Arabic instead of English, also known as the SCCA. So this is also a commercial arbitration, but in Arabic language. We have also sent out tips for SCCA this year. And also next, we have the Sports Arbitration Mooting Competition, SAMCO. The area of law, as you can see, is a sports law. So this Sports Arbitration Mooting Competition is actually very new competition, which was first organized back in 2021. So this year is the second year that we have sent out our teams. We had actually ended yesterday. So the highest accomplishment that we have secured for SAMCO is we came out as the semi-finalists for last year, and at that time I was a coach for SAMCO. So the next competition is the International Islamic Banking Finance Arbitration Mooting Competition. Such a very long name, but the one that we always address this competition is as IBFAC. So this type of arbitration is focused on the Islamic banking and finance arbitration. Actually, this competition has not yet been in existence. This is the first year that we are participating, and we are organizing this IBFAC. So IBFAC is actually a project which had been handled by our seniors since 2018, and we only managed to organize it physically during this year, in which we collab with the AIAC, Asian International Arbitration Center, which will take place inshallah by this October, and we have opened the selection for our mooters to participate in this IBFAC. Also, last but not least, the William C. Viss Commercial Arbitration Moot Competition. So if moot court competition, the biggest competition is JASIP. For arbitration mooting competition, the biggest moot competition is the LexMoot. This one, the one that I mentioned, and the one that I participated, William C. Viss Commercial Arbitration Moot Competition. So for this year around, which we would be participating for next year, it usually takes place around August up to April. So we have like a lot of time to prepare for this Williams. And the one that we sent out teams has ended for this year during last April, and we are looking forward to participate in this William C. Viss Commercial Arbitration Moot Competition, inshallah, by this September, after they have opened up the registration. So these are the few of the moot competition that we have entered and we have participated. We have sent out teams, and among the accomplishments that we have secured throughout the years of being in the mooting competition. All right, so as I've mentioned earlier, when we moot, or when we are presenting our argument, what exactly are we presenting to the judge? What are the arguments, and what makes up mooting? Basically, what are the things that you want to present before the judge to represent your client? So we have two parts in mooting, especially in written submission and also in oral submission: the procedural part and also the merits part. So the procedural part, the one that you would have to present first before the judge, is the procedural. So as you know, in mooting we have two speakers, right? Two counsels. So the first counsel would be addressing the procedural part of the issues itself, and the second speaker would be presenting on the merits part of the dispute. So the procedural part, basically, you would have to determine the jurisdiction of the court or the arbitral tribunal. So basically, it's about determining the law applicable to the merits of the dispute. So because the judges or the arbitral tribunal would have to know whether they have the jurisdiction, whether they have the power to listen to disputes in the first place. So this counsel will be arguing that if the claimant sides, they would be arguing that yes, the jurisdiction, there is the court or the arbitral tribunal have the jurisdiction to listen to this dispute. And on the other side, the respondent will argue that no, the arbitral tribunal or even the court does not have the jurisdiction to hear the dispute. So that's basically what is happening in the procedural part. And also, they have to also determine the law applicable to the merits of the dispute. In the second part, you would have to determine what are the contracts, what are the statutes that should govern the whole proceedings itself, whether the Contract Act is applicable or not, or whether the Contract Act, the Sale of Goods Act is applicable to the dispute or not. So it's a matter of determining the procedure or the law of the case. And in procedural, we focuses more on the law. So when you are hearing the counsel for procedural is submitting, you would listen to a lot of laws as been laid down by them, and not only confined to statutes, but also case laws, books, and also journals. So that would be for the procedural part. And the second part is for the merits part. So the merits is the real issue, we call it, the substantive issue of the dispute. So if procedural is the procedural law, then merits is the substantive law, because it will determine the breach of the defaulting parties, the remedies, and what's available. It actually you are submitting on the real issue of the dispute itself, like who breached the contract if there is a contract, who defaults in these terms of contractual relationship between the parties, and what are the remedies that are available to the parties. And also, next, the merits focuses more on the facts because it concerns with the dispute as opposed to the procedural part of the mooting. Right, so this is the example of how it looks like for merits. Like this is the dispute. Like there is a dispute on the variation of the contract, the changes to the contract, whether it is valid or not. So just a quick view of how this merits look like, because it's a dispute is how like you would see in your final exam problem is the problem itself. Merits is the problem itself. What is the dispute that is faced by both of the parties? And next is the procedural part. So the procedural part, you would see that this is how it looks like, because it actually talks about, or it actually seeks to find what shall be the governing law for the arbitration agreement. So in procedural, you would have an arbitration clause, and that arbitration clause is often the disputed things, because that arbitration clause will set out the who should we turn to in the event of dispute, and how many numbers of arbitrators should we select, how should we select. So these are the disputed things when it comes to procedural. All right, I would like to present just a short demo for mini mooting. For moot court settings, it's between the appellant and responding, and the respondent is an appeal case in the Court of Appeal. So I will hold on. All right.
The Ahmad Ibrahim Court of Appeal is now in session. Yang Arif Muhammad Munir Lalma.
Can you guys hear the audio?
Yes, we can.
All right, thank you. Okay, so here we'll start off with the bailiff introducing the case number, who are the parties, and who are the counsels.
Mahmud is presiding. The case before the court is concerning the appeal by Ms. Fatini against Sekawan Faris Sekian Berhad and others. The appellant is Ms. Fatini and the respondent is Sekawan Faris Sekian Berhad and others. The appellant and respondent are each allocated 10 minutes to get their plea.
The court would now like to call the counsel for the appellant to begin its submissions.
Please this honorable court, Syed Ashraf, acting on behalf of the appellant, and I humbly request 10 minutes of this court's time.
So here, as you can see, we have the judge, only one judge who will be presiding the dispute, and we have a counsel for the appellant, Ashraf, and also the counsel for respondent, AB. So Ashraf, as the appellant, will be starting first to submit his argument. So since this is a moot court settings, which aims for demonstration, we do not showcase to you like there will be two counsel for procedural and merits. This is just like a general view on how a mooting will look like. So he would be, so as you can hear just now, he is introducing himself, and he is also introducing the time allocation for his submission. That would be the formalities when it comes to mooting competition or moot in general.
The appellant in this case has suffered huge loss where a vegetable farm, which uses to grow crops for food, had been completely destroyed due to the conduct of the respondent. And conduct here is referring to the constant explosions that occurred in the respondent's limestone farm, which had then led to the collapse of that limestone hill over the appellant's farm. Now, Yang Arif, this appeal today is made call for a review of the decision of the trial court, which had found that the respondent's quarry operation was not the cause of the damage occurred to the appellant, consequently dismissing the appellant's entire claim for negligence. Therefore, Yang Arif, this appeal would only concern one element of negligence that is being disputed, which is possession. For this reason, the appellant has one submission to make before the honorable court, and that is the causative in the respondent's quarry and the collapse of the hill. Now, there are 2 points.
So as you can see, he starts off with this again introducing himself, stating the time allocation, opening statement, the opening remarks of the case generally, and also he would be telling the court what is his point of submission before going into the detailed arguments.
points that I would like to make under this submission. First, that the material contribution test should be applied in determining propensity. And second, that the respondent has fulfilled the test. I'll turn to my first point. In order for the appellant to succeed in this claim, it is essential to first prove that the damage caused to the appellant was due to the respondent's activity. Or in other words, that there is a link between the damage and also the wrongdoing of the respondent. And in determining this link, there are a few ways or tests that can be used by the court. And the learned trial judge had applied the but-for test. However, it is our submission that such a test cannot be applied to our current case. And this is because the but-for test would not work in situations where there are multiple causes contributing to the damage, because it would definitely negate anyone's liability. And
what do you mean by negating anyone's liability?
So as you can see, the judge is asking a question to the counsel. So this counsel would have to respond to that judge in his submission. Let's look at how he's responding.
This is because to apply the but-for test, the question that must be asked is, if it wasn't for the defendant's activity, would the plaintiff have suffered the same damage? Of course, when there are multiple causes, the answer to that question would forever be a yes, because there are other causes. Therefore, this would discharge anyone's liability, even if their conduct was in fact an important or material factor to the damage. And this was affirmed in the federal court case of Wu Xiu Ye.
So, as you can see, he is answering the question of the judge and straight away incorporate that answer into his submission by providing an authority. So that's basically like how it looks like for a mooting to take place on part of the appellant. So to save time, I would now shift to the respondents, like look at how respondent would submit her case.
May I please Arif? My name is Amy Hana, appearing on behalf of the Kalan Quarry and Construction Sudiran Berhad, correspondent. I humbly request 10 minutes for my submission. Before I proceed, allow me to highlight some facts which have been omitted by the appellant today. First, the collapse had happened after heavy rain and fall along Sudiran spot, but the quarry was also not in operation during the collapse, starting from 3 days before the event. And second, there were no common signs of rockness, such as the projection of broken rock.
So as you can see, the respondent, she will be responding the points that have been made by the appellant to rebut his argument. So the appellant, as you can recall, he actually lays down a brief facts on the part of his client. And now the respondent is rebutting that facts by laying out a set of facts that is heavier or that will be siding with her client as a response to the facts that was brought up by the appellant just now.
Accompanied by ground trauma, rock falls, and concussion. Third and lastly, the respondent had taken the safest blasting method called the giant-hammer method, which produced less intense vibrations. Having dealt with the facts, I shall now begin in responding to the appellant's submission, in which we submit that there is no causal link between the respondent's quarrying activities and the collapse. The appellant today had relied on the material contributing test and contended that the respondent's quarrying activities had materially contributed to the collapse. While we do concede that the material contributed test is applicable to the current case, considering that there were 7 possible factors of the collapse, we submit that the respondent's act cannot be said to be the material contributor. And this is because, the respondent's act falls under the manifest non-current acts, which is a factor insignificant to the injury.
So you mentioned the Latin principle just now. has that Latin principle been adopted by the local courts?
Indeed, Arif, the High Court in the case of Alliance My One Thing against Dr. Lane had adopted this principle in relation to the material question defense act. And coming back to my submission, the appellant.
So now there is a fine difference of answering the question. If you look at the appellant's way of answering the question, when he answered the question from the judge, he incorporates it into the submission. So that is the first way of answering the question. And as for the respondent, how she answers the question from the judge is by straight away answer the question. And after she has done with answering, she goes back to her submission. So this is what we call as advocacy style, and how flexible you are in answering questions from judge, because you have to also, there are a lot of things to observe when you are presenting your oral argument. Firstly, you have to present your argument, and then you'd have to also answer the question from the judge, and also to have some kind of transition between answering the question from the judge and also going back to your submission. And last but not least, you would also have to observe the time, because you are only allowed to speak between the stipulated time based on the requested time, because you have first mentioned that you request 15 minutes, right? So that 15 minutes is only the time where you are allowed to speak or to give your argument. If you exceed that time, usually the marks will be deducted. All right, so having done with the mini demonstration, so I guess that would be the end of my slot for the introduction to Mooting. Basically, I have talked about how this Mooting looks like, what are the available settings for Mooting when it comes to moot competition and stuff. But one thing that I also would like to highlight is that when it comes to Mooting, it does not only confine to going into competition. Okay, always take note of that. It helps you in every aspect, as I have personally experienced it. And in fact, Mooting is also available in your syllabus when you go to law school in ICOL. In your second semester, you would be dealing with your subject of compulsory moots. And in compulsory moots, you need to remember that the lecturer will not be feeding you with all kind of things that you learn when you go for mooting competition. Usually they will only focus on the things that you learn in your classroom per se, which is as opposed to when you go for mooting competition, you will learn a lot more than what you gain during your classroom. So it is actually better to expose yourself to moot competition as mooting, and also be it arbitration or even moot court settings, because it helps you to gain more than what your fellow classmates that does not go into mooting competition that will gain when you are going for your compulsory moots. And also one thing you need to remember as well is that despite going for this compulsory moot classes in your second year, in your final year, the subjects will focus on the procedural subjects, which means that you will not be learning theory again in your final year. It's about a matter of practical. So almost every day you would have to go for hearing, you would have to simulate a court hearing session, which is very, very busy. So this is the very important aspect of mooting, that if you manage to tackle it as early as possible, then you will not have any problem at all if you have to keep on submitting in front of your lecturers when you go for your final year. So I guess that will be all for my slot. I will pass back to Sister Nur Batrisha. Thank you.
All right, thank you so much, Sister Mina, for the amazing sharing just now. So there are a lot of new things that we get into in the introduction to the mooting session. So now we finally know how mooting and arbitration works. And I like how Sister Mina mentioned just now that mooting can actually boost our confidence. It helps us to extend our knowledge and our law understanding, because it requires a lot of research, right? And I just acknowledge that actually there are a lot of mooting and arbitration competitions that we as law students can join. And it is also very impressive how Sister Mina and the team have achieved so much through the competition. So now moving on, how was the session just now, everyone? Are you guys still energetic for the next session? I really hope you guys are, because we are now moving on to the second slot, which is Memorial 101. And I have been wondering what is actually Memorial 101. So without further ado, I would like to invite our handsome speaker, Brother Muhammad Ashraf Hakimi bin Said. Please welcome.
All right. Hi, everyone. Can you hear my voice clearly?
Yes, you are audible.
All right, thank you very much. But can you make me be able to share my slide? It's okay then. Take your time. Can I just start first? Okay, nice. Thank you. Which one? Yeah. All right. This one. Okay. Ini macam ni pula dia. Can you see my slide, guys?
Yes, we can see your slide.
All right. Nice. Yeah. Okay. Okay. Yep. All right. Hi guys, Assalamualaikum warahmatullahi wabarakatuh. To my juniors from Center for Foundation Studies, IIUM. You know guys, looking at you has reminded me of my good memories in foundation. The moment where I thought I have really know what the law is all about, but actually it's just 1% from the real legal field. So beginning with the introduction of myself, my name is Ashraf Hakimi. I'm a third year, second semester student, entering my final year of LLB degree. But if I decide to continue my LLBs, inshallah, I will have another one in addition. And inshallah, we can meet in ICOL later. And currently, I'm the officer for IIUM Student Union, specific for Office of Education, which just newly appointed last week. If you guys are aware, that our campus has just, our IIUM has just finished the election, right? So I'm from CFS also, same as you guys. I'm originally a product of IIUM from the foundation. But during our time, we have our foundation in Kuantan campus. And I'm still remember the batch that is next to us is the first batch. What was the first batch who have fully stayed in Gambang? And if I'm not mistaken, you are the third batch. So if I begin with my sharing session, it's okay, just make this session as a chatting session between seniors and juniors. Don't make it too formal. I want to remind you that being a law student of IIUM, which we call as ICOLians, and which by the end of this foundation period will be joining the main campus in Gombak. I want to remind you that ICOL has a great history in Malaysian law. We are the pioneers of many things, and one of them is mooting. Mooting is not merely a competition. Mooting is not merely about skills, but indeed, for ICOL, it's a legacy. I can tell you that many law schools in this world start knowing ICOL by mooting. Previously, we were the runner-up of just mooting competition in the final global round. We have great reputation in Law Asia. We are the lion in arbitration mooting competition. But if I may convey this honest message to you, currently, we lack of super mooters, especially in my batch. And this is the reason why today, Mina, Khairil, and me turun padang to convey this message to you. The legacy of mooting in ICOL is in your hand, because in 1 or 2 years, me and Mina will leave this mooting field, and you guys are the successor. I can see that when Mina explained one by one the achievement of IIUM mooters, one of the audience, Ahmad Ziad, his mouth like, wow. Yes, it's a wow achievement. And after this, you, Ziad, and your friends need to be our next mooter when we join ICOL in Gombak later. Imagine during my first year and until now, which I nearly entered into my final year, from 250 students in ICOL, only me and Mina who are currently active mooters. Gladly, we have Mina who can win every single competition. And I can say that Mina can be a good idol for you guys if you want to join mooting later. Although both of us start from first year, but she started earlier for me. Her passion in mooting is unbeatable. But we cannot just stop with Mina. We can only have one Mina. We need to have second Mina, third Mina, and more Mina in ICOL. And that's your job, guys. So continue about my journey in mooting. Actually, during my CFS and my first degree, I'm just active in debate arena, the specific Malay debate. And until one time, there is one specific senior. He was the president of Moot Club during this time. His name is Fayaz Adesta. If you know him, he said to me that, Ashraf, I can see something in you. I see that you will be the asset for mooting for IIUM mooting. I said to Fayaz, no, I can't. I'm busy with debate. I have nothing for mooting. But he encouraged me, he persuaded me. And during my first selection, I was selected, beating other students from second and third year. And after that, that was my first competition, NAMCO, Novice Arbitration Mooting Competition. And then I joined Law Asia competition. And after that, there is one program conducted by UUM called Malaysian National Arbitration Competition, Training Competition. Sorry, Malaysian National Arbitration Training Camp, sorry. And I was appointed as trainer for students from UKM, UUM, and TELUS. And my mentee has emerged as the best respondent team in that program. But I want to tell you something that if you ask IIUM Mooter, is joining mooting competitions all about winning? If you ask this type of question to mooters like Mina, perhaps the answer is yes, because she has won everything. But me myself, I don't have any great international achievement to be proud of like Mina. But me myself got special recognition from the judges that really encouraged me to love this field. You know, when we go to the mooting competition, we'll be submitting in front of real judges and credible lawyers. And personally for me, it's really an honor when I've submitted in front of Yang Arif Faizah Jamaluddin. And she said to me, Ashraf, I can't wait to see you in my court letter. The new mooters of the new style of thinking and the fresh argument is really needed compared to our current lawyers yang dah lama sekarang kan. And that makes me really love mooting. And that's the reason why even tak menang-menang lagi, but there is something yang still encourage kita untuk pursue in this area. All right, so Mina has introduced to you what is mooting in general, and it's my turn to explain specifically regarding the written submission. Now, what is a written submission? I want to answer this question by giving an illustration to you. Have you ever seen when the lawyers come out to the court by bringing a huge bag full of papers inside it? Or even you have encountered in any movies, bila lawyers bawa bag besar-besar, or the judge read something in the court, and also there are a lot of papers in front of the lawyer's table. Apa benda sebenarnya itu? One of them is a written submission, and also bundles of authorities. That's the reason why also why people always say that lawyers is actually killing trees. Lawyers ni kerja dia asyik nak print paper. Sebab apa? Sebab benda ni lah. Written submission and also bundles of authorities. Currently, if you guys know this case, I don't want to say her name, but she's very famous right now. Kalau korang tengok lawyers dia bring a huge bag when they enter into the court. What inside this bag? That is written submission and also bundles of authorities. Now, the next question is, what are the components of written submission? Here are. First, we start with cover page and then table of contents, index of authorities, summary of facts, submission and argument, and lastly, pleading. All right. kalau kita cakap je kita tak nampak kan. Let's see the example. Yeah, I'm sharing my slide. Alamak. Yeah. Actually, I joined by using two device. Wait. Committee, can you make my second device also as the co-host? Same name, Speaker Shahakini. Is it possible? All right, thank you very much. All right. Can you guys see my slide?
Yes, but it is not showing the slide yet.
Okay. All right. Tak salah nak tengok sendiri. Okay. Allahumma salli ala Muhammad. This is an example of excellent, I can say, written submission, whereby this is this written submission has won best written submission in Tun Sofyan Mooting competition. Our team, this is from IIUM team. Our seniors, and most of them I think has graduated from ICOL, and this competition was just held last semester, if I'm not mistaken. Please don't take any screenshot. If you want this document, join ICOL letter and then be our mooter. Okay. All right. Now, let's do one by one. What are the components of written submission? Starting with, starting with this one. We call it as cover page. Cover page we has the card, the appellant site, and also the respondent site. And it's also stated here, memorial for appellant. This is what we call as cover page for a written submission. After cover page, we have table of content. It's like our assignment, kan? Table of content, whereby we have every heading and subheading of the written submission. I will explain this further later. And then we have index of authorities. If we are doing our assignment, kan, we put the references on the back, on the last page of our assignment. But for this format, we put the index of authorities in the front. We have starting with cases, then statute, journal articles, website, dictionary. And then we have statement of facts. Statement of facts here is very important. As Mina said just now, we need to create the narrative specifically from our side. If we are the appellant, we need to show the narrative of our side. Jangan pula kita letak facts yang sah-sah akan bagi side kita kalah. No. Okay, we need to be more creative. Bukannya kita conceal the fact, no. But we need to be more creative. Okay, this is statement of facts. All right, next, what component do we have? Then we have pleadings. Starting with A ini the first submission, and then this is the argument. Submission is what you want from the court, the main thing that you want from the court. And then you can continue it with argument. And then this is the submission. This is the second submission, first argument for second submission. Continue until the last page, which we have prayers of relief. Prayers of relief is what you want from the court. As simple as that. What you want from the court. Okay. One submission will have one prayers of relief. Okay. Now, I want to explain one thing. Yeah. Okay. This is the most crucial part. I know that most of you has learned about IRAT, kan? Kan? Good. Because I know that. Okay. Because I know that your syllabus is totally different from my time, and your syllabus also learns about contract law, constitutional law, and others. Am I correct? Yes, nice. And for sure, you also know the concept of IRAT. So what I want to emphasize here is that when you are creating your argument letter, even in your written submission, still follow the same concept of IRAT. But a written submission is the simplest and the most straightforward concept of IRAT. I repeat, the written submission is the simplest concept of IRAT. Why I'm saying like that? Because, okay, let's take a look. If we have IRAT, kan? IRAT. The written submission, okay, sorry. If we do our IRAT, we'll start with the first one is whether defendant has breached his duty of care. And then the rules, perhaps we use the case of Donoghue Stevenson. Kan? Korang tahu kan case ni kan? And then we make application, letaklah dia buat apa-apa, did something, breach. And then conclusion, defendant breach duty of care. Okay. This is the simplest part of IRAT. And same goes to when you are writing your written submission letter, just follow the same concept. But if I can show you that, if we are looking into the table of content, can you see what is the whether part? The issue part. Ada tak? Ada kan? Dia terus start with the submission. And so this is submission, this is submission, and then this is argument. Okay. Can anyone tell me why in our written submission we don't have issue? Kalau siapa dapat nanti belanja Grab apa-apa ke, Grab food ke, food panda ke. Come on, 5 seconds. 5, 4, 3, 2, 1. No, okay, selamat duit aku. Alright, because remember this one tau. For mooting, for written submission, you are submitting to the judge. You are the counsel. You need to present your argument, not issue. In front of the judge, there are issues, and the judge will decide the issues based on the argument made by both parties. So as counsel, you can't say you submit issue, but you submit submission or argument. You got it? Okay? So same goes to the concept of IRAT in written submission. When writing the written submission, you need to know that you are submitting to whom? To the judge, not to the lecturer. If you are answering your exam question, yes, you need to answer it holistically and with the most complicated way because you want to show to your lecturer that you read that topic. But for mooting, you need to treat the readers, who are the judges, and also your opponent, as someone who does not know anything. But you explain it in the simplest form. Okay. For example, when I have show you the example when we do our IRAT just now, kan? Buat simple je. Tak perlu pun buat ayat panjang-panjang. No need to complicated sentence, long paragraph. just be as straightforward as much as possible. Okay, that's my first tip. Second tip, okay, this one is also applicable when you are answering your final exam or you are doing your assignment. Make sure every point here is connect to each other. Okay, why I'm saying like this? Because the mood problem is very complicated. So there is possibility yang you boleh terbabas ataupun termengarut to isu lain yang akan buat readers tu jadi pening. Okay, I show you one example. Mana? Okay, this one. I don't want to say which university is this, but this is the real written submission yang for me we need to avoid lah written submission like this. Okay, if you can see here, the argument is the respondent breached their duty of care to the appellant. Okay, dia nak cakap pasal duty of care. Sorry, dia nak cakap pasal duty of care. But then, okay, dia cakap pasal concept of forcing, and then dia buat application, and then tiba-tiba dia cakap pasal reasonable person. Actually, there are a lot of things yang ada dalam ni which dia mix up tau. Wait ya. They don't have a clear structure. Instead of following IRAC, arguments in this written submission are just list out without making it clear what is the applicable law, and therefore what standard is being used to the judge to judge the facts against. And this person also does not separate out different arguments into subheading, or at least different paragraphs. The arguments about forcibility, the reasonable precautions are discussed together. So the reader is unable to differentiate them, differentiate them. And finally, this submission do not link the argument to the issue. Cakap pasal macam-macam dalam ni, which is actually dia nak cakap pasal duty of care. Okay, and this makes it very difficult for the submission to assist in the overall argument. Okay, now let's look into another example, which is a good one. Even kita tak baca lagi, kita dah nampak it's very structured. And each issue and sub-issue are identified clearly. The relevant law is well out and well structured. Not only this submission persuasively apply the law to the fact and in a concise and methodical manner, but each argument also link back to the issue. You can see dia punya structure tu kan. First, dia cakap okay, duty of care. And then dia explain betul-betul. Duty of care ni has two elements. This is the first element, this is the second element. And the first element dia explain satu-satu. Dia tak mix up benda tu dalam one paragraph macam yang ni. Okay, that's the very basic of written submission. And this aspect of mooting is a great way to develop your skills in legal research, drafting legal argument, and practicing legal citation. Tengok ni dia buat citation. Ambil training nanti dia letak footnote lah. Macam tu. Okay, so now you can see the difference between bad written submission who mix everything and also good written submission who make it very structured manner. Okay, all right. Now, coming on to our best written submission here. Okay, I want to show you that, for example, kan. Okay. Okay, this one. This is the submission, and then this is the first argument. Okay. Tengok macam mana disusun. It's very structured. First, they lay down the main principle. Main principle. Second one, they lay down the rules. And then dia buat application. Sorry, application dia sampai sini. And then finally, the conclusion. Each point ni is very connect to each other. Very connect to each other. Dia tak pergi jauh, dia tak merepek. Okay, this is the first thing about structure that I want to emphasize on. Second thing that I want to explain is, okay, now dekat argument ni, dia nak cakap yang section 16 of Selangor Criminal Offences Enactment is not under the jurisdiction of state list. Korang dah belajar kan constitutional law kan, which is the principle of ultra vires. Ni bukan ultra vires ni. State law cannot make laws which under the jurisdiction of federal laws. Tahu kan benda tu kan? Alright, nice. So, benda yang nak tunjuk dekat korang adalah macam mana dia buat setiap satu ni connect to each other. Okay. Dia punya submission is section 16 of SCOE is invalid on the ground that legislature of Selangor has no power to make laws. And then dia cerita pula the next subheading. Why? Because benda tu falls within federal list. Tengok pula the next subheading yang dia buat. Lepas dia cerita benda tu bawah federal list, dia tunjuk setiap satu kat mana federal list tu. First, dia violates item 21, and then item 4H, and then item 4K, and then item 22. Macam tu. So, every subheading tu, every paragraph, bukanlah every paragraph, setiap satu topik yang dia nak cakap tu, dia buat subheading yang baru. So, bila ada subheading yang baru, only that the judge will help the judge to easily understand your written submission. It's not like you mix it into one paragraph and then you put everything into that one particular paragraph. Okay, now let's say the next submission. The next submission is regarding section 16. Section 16 is null and void for violating Article 11, Article 10, and also Article 11. Okay, then the first argument, Section 16 violates Article 10 of the Federal Constitution. Second argument, Section 16 violates Article 11, which is, if you can see here, the second argument relating to the Article 11 and the first argument relating to Article 10 is really related to this submission. Can you see the connection? Maksudnya, your submission tu must have connection to the first argument and second argument. Same goes when you do your assignment letter. You need to ensure that your subheading, your subtopic must be related to each other. Okay, let's say to the next submission. Syariah jurisdiction, Syariah court has no jurisdiction over a person professing the religion of Islam. All right then. First argument, SPSB cannot profess the religion of Islam. And then, dia bagi reason here. Second, lifting the this concept korang tak belajar lagi. It's okay. But I want to emphasize to you guys, when you have a very structured and clear heading, that's the reason why people can easily understand your submission from your table of content itself. Which means, even when you are doing your assignment letter, if people can understand your submission or your assignment by merely reading your table of content, that means your subheading is correct enough. Okay, let's say one by one. Okay, let's say kita tak baca lagi lah dia punya submission tadi kan. Mula, okay, this one ni we have understand it. Let's see. The first submission which we discuss about Section 16 invalid on the ground that SSLA, the State Legislative Assembly, has no power to make laws. And then first argument, he explained about this matter is not within the state list, which is it's fall under the federal list. And then he explained one by one. So we can know, oh, so the first submission is about state has no power to make lists which fall under the federal list. Then what are the federal lists? Which provision that prove that this matter is under federal list? Item 21, item 4H, item 4K. Macam tu. And then second submission, null and void for violating Article 10 and 11 of the Federal Constitution. Why? Because the restriction of fundamental liberties must be restrictively. And the second one, he used the proportionality test, ada 3 elemen. And in our case, it failed first element and third element. Macam tu. So what I want to show here is, we can understand the written submission by merely reading the table of content, which prove that the heading, the subheading, the topic, the subtopic has been arranged in a very structured manner. Okay, you get it? Nice. All right. Now, ikutlah present yang ni. Mana nak stop ni? All right. So, coming on to the next part, which is, all right, this one. Research. Mooting, like Mina said, actually mooting has a lot to do with research. And as a law student, you cannot run from having a good research skill. Okay, so what I want to show you right now is that, yeah. No. Oh, okay, nampak kan? Okay. Have you guys very familiar with LexMoot? Sure can. All right.
Yes.
Very good. Nice. I don't know you guys, but I assume, of course, lah, you are better than me, can. But during my foundation time, when I guna LexMoot ni, I just terus search je. Contoh, siapa yang famous? Niza and Zamri. Terus search macam tu je. But actually, for mooting, you need to avoid this if possible. Why? Because usually for mooting kan, you will get sometimes kalau if you have risky, you will get moot problem yang areas of law tu familiar dengan you. But during my first year, I have joined a mooting competition which involved private international law, whereby kita tak pernah belajar pun ISG apa semua tu, unit law principle, have never learned that. So what we need to do is we need to, okay, first we need to identify which area of law that we need to learn. Okay, so jap, lupa jap. Mana ya? No. Ke situ. Allahumma salli ala Muhammad. Okay, tak apalah, abaikan. Okay, what I want to emphasize is, one of the best way for you guys, this is for national law tau, local law punya. When you got one issue and you want to get an eagle view of the issue, don't just terus jump untuk cari case. Jangan buat macam tu. But instead, my suggestion is, you need to read this first. Hasbury Laws of Malaysia. Nampak ni? Hasbury Laws of Malaysia. Why? Because in this House Laws of Malaysia, it has arranged the subtopic, the all general principle, the exception in a very structured manner. For example, kan, okay, let's see one by one. Use apa? Okay, Housebury. All right, Housebury Laws of Malaysia. So, for example, on the issue of competition law. Competition law ni, later you will learn this subject in your second or third. All right. Okay, tengok ni. Macam mana dia susun. Everything relating to competition law, dia dah susun dalam ni. Macam tu. Okay. For example, if the issue is regarding vertical agreements, okay. Tengok macam mana dia susun. Actually, Housbury Laws of Malaysia ni is like a textbook tau. It's like a textbook. If you have the physical version, okay je, cuma susah lah korang nak search. But for me personally, I more prefer the digital version because it's more structured, I think. Tengok ni, disusun semua start from the very general principle, and then it also laid down the important and landmark cases. Macam tu. Okay. I will say Housbury Laws of Malaysia is the best place for you to start your research for national law lah. Okay. This is specifically for competition law. If you have Housbury Laws of Malaysia also have equity and trust, company law, contract law, semua dia ada. Semua areas of law dia ada. So just find it in your LexMoot. Okay. Let's look to the other one. Regarding, okay, my favorite part is this. Which one ya, jap? Lupa dah. Latest update, yes. Latest updates. Latest update ni, if you guys really know how to use it, this can be a great weapon to beat your opponent. Okay, tengok ni, dia punya latest update regarding competition law is on 2019. Let's see apa yang dia ada. Updated cases, updated guidelines, updated legislation, updated subsidiary legislation, updated treaties and convention. Let's see updated cases. So, by using this platform, you can know what is the latest case regarding competition law. Kalau kita search 2019, okay, tak ada. 2018, ada, one. So, this means this case is the latest case regarding competition law. Nampak kat situ, you dah a step further compared to your opponent, because your opponent will rely on their landmark case, on their textbook case, but you have the latest case regarding competition law. Okay, dapat? Thanks. That's my tips, I think. All right, let's get back into the homepage. I want to emphasize that ni semua ni quick find, publication, all these you need to utilize to have a good research. For example, define terms ni. Kat sini you boleh check duty of care, and then LexMoot will bring you to the best definition of duties of care. So dia ada kat sini. Instead of you just search dekat atas ni je. Okay. Remember, in Mooting, of course lah, we need to prioritize the cases and also the legislation. But if you can utilize the subsidiary legislation, that will put you into another level compared to your opponent. Sebab nanti usually lah kan, in moot court competition, banyak je case yang court tak pernah decide yang you kena suggest decision baru. So kalau you nak cari benda-benda yang dah ada, decision yang dah ada, susah. That's the reason why you need to utilize the secondary legislation. Secondary materials. Okay. You got it? All right, nice. Thank you very much. Next. Itu lagi yang kita tengok kita boleh manfaatkan. Okay, this one is my favorite lah. I know you of course you have learned this in your library skills kan, but I can say that even my friends pun tak ramai yang guna benda ni. Skills ni kalau korang ada, korang memang senang sangat nak buat assignment and also for written submission. Ingat ayat ni tau. You need to be creative to play with the important words. Important words. I repeat, important words. So, bila you ada specific words yang you nak cari, barulah you punya research tu lagi betul-betul spesifik. Tadi I dah ajarkan macam mana kita ada isu yang sangat general, kita nak dapatkan the eagle view of our research. And now I want to show you guys how to be very specific in our research. For example, tadi kita baca written submission tu pasal duty of care. And then the case is about slippery floor. Kan? Ingatkan tadi kan? Okay. So, if you want to find a case that you want to refer to, it's better and it's very good if you can show to the judge that your case lagi rapat dia punya facts compared to your opponent case. Maksudnya, okay, both appellant and respondent will show to the judge yang, okay, we have present the case regarding duty of care. But if you want to win the tournament, you need to prove that your case regarding duty of care lagi tepat untuk menjawab isu pasal kes kita tu. Contoh, if our case is regarding duty of care and the application pasal slippery floor, jangan you cari application, jangan you cari case pasal rumah runtuh. Even dia punya principle pasal duty of care. Macam tu. So, main dengan word tu. Okay, let's say tadi kita punya pasal slippery floor tu kan. Duty of care and spring. Ada tak? Agak-agak ada tak? Kalau tak ada, kita tukar word lain. Ada 18 cases. Which is, 18 cases ni, semuanya pasal duty of care and slippery floor. Nampak? Non-slippery condition. Kalau pasal ni pula, slippery floors. Nampak? Sekarang you dah ada case yang lagi rapat dengan isu kita, instead of you ambil mana-mana case pasal duty of care yang tak ada kaitan, bukanlah tak ada kaitan, ada je. But facts dia lagi make sense kalau you guna yang ni. Macam tu. Okay. So this is my tips for how to do your research. Alright. Now, let's continue. Okay, coming on to my final tips. Alright. Yeah. Okay. Brothers and sisters, I want to emphasize that mooting is all about logic. When you got your moot problem, you need to understand that the moot problem has created in a very fair manner for appellant and respondent. So perhaps you will have same legislation, same cases, and perhaps same argument. But cara kita nak menang dalam argument dalam court is by proving that your logic is better than your opponent's logic. That's the first thing that I want to emphasize. Second, you need to understand that judge, even yang Ahmad Arif, Marilyn tu pun, they are human. Human akan kalah dengan sentimen. Okay, which means bukanlah I nak kata you tak payah you letak semua tepi you punya authorities tu and play with sentiment. No, bukan macam tu. But perhaps after you lay down your principle, your argument, your case, your best application, play with some sentiment. And with that sentiment, perhaps judge itu akan rasa lembut hati dia untuk bagi you menang. Remember, mooting is not like debate. Debate, you need to prove that, oh, your opponent is strong, your opponent is weak, and you are the best speaker in that room. No, that's debate. But for mooting, you need to encourage, you need to encourage the judge to be on your side. Kena ada daya memujuk sikit. Macam tu. Okay? That's my second tip. My next tip is, okay, this is the one of the most crucial part in your written submission. Okay. Mood problem tu, sometimes there are mood problem which have 60 pages, 70 pages, and even 100 pages. Yang menentukan perbezaan partis yang menang dan yang kalah adalah macam mana we can show to the judge that we can simplify all these complicated facts ni dalam ayat yang paling mudah untuk difahami. Okay, I repeat, sometimes mood problem dia ada panjang sangat. So, yang menentukan konsel yang menang dan yang kalah adalah macam mana kamu berjaya buktikan yang sebenarnya isu kita ni sangat mudah untuk difahami. Okay, that's the reason why we have seen the written submission yang menang Tun Sofia Mooting Competition tu kan, wordings yang dia guna sangat simple, sentence yang dia guna tak panjang, paragraf dia pun tak adalah sampai satu muka surat full. Tak, kita buat macam tu. Sebab apa? Sebab dia nak buat readers easy to understand the written submission. Okay, you need pola I tulis tu selia, is clear, okay? Sorry, typo. You need to be clear and concise. Okay, jangan kalau macam I train my team during tournament kan, or even with my teammates, we're not reading our mood problem. Sorry, can you hear me? Hello, can you hear me?
Yes, we can hear
Alright,
you.
sorry, my connection is unstable. When you are reading your mood problem kan, let's say you look into one specific sentence, and then ask yourself, ayat ni betul-betul perlu tak dalam written submission aku? Kalau cuma sekadar menambah panjang, just remove it. Replace with another sentence which strengthen your argument. Macam tu. Okay, ingat tu. Remember, written submission is not your written assignment to your lecturers. Okay, you need to be clear and concise as much as possible. Okay, and one last thing I want to say that sometimes Allah dia bagi anugerah dekat few mooters yang ada ability to think outside the box. So in mooting, you need to use that. Okay, all right, thanks. Okay, I think that's all the tips from me. I've presented to you what is written submission, what are bundles of authorities, the components of written submission, how to do written submission. Basically, it's just start with IRAC, but then you need to master on it and then how to conduct research in mooting, and lastly some tips regarding written submission. Okay, I want to convey one final message from me. I have one hope to you guys, that you will join mooting when you're in Gompak campus later. Remember this word, you are the successor. You need to continue this legacy. The way of a mooter seeing one law is very different with other law students. Cara mooter tengok satu law dengan cara student yang biasa tengok satu law berbeza. Mooter, dia nampak satu ni, dia akan boleh buat, okay, submission first, argument ada 3. Submission second, argument ada 3. Oh, ini appellant side. Kalau respondent side pula, dia boleh bidas macam ni. Mooter dia ada daya pemikiran yang sangat luas compared to other law students. Okay, That's the reason why I really encourage you to join Mooting when you are in Gombak campus later. Okay, be like me now when she just entered first semester, terus dia cari Mooting, terus join Mooting and see where she is now. Okay, like I said, kita tak cukup dengan hanya ada seorang Mina. Kita nak ada Mina kedua, Mina ketiga, dan banyak lagi Mina. Okay, and even if you tak ada rezeki pun untuk dapatkan international achievement in Mooting, the moment you can submit in front of the real judge, it's very special. Okay, you know, that kind of recognition from the real judge, from credible lawyers, that's really push you further. And that personally for me pun, that's really makes me love the law better. And I want you to be better than me. Kembalikan semula zaman kegemilangan Icol yang sangat hebat dalam Mooting dulu. Kita pernah jadi nombor 2 dunia. Malangnya lepas tu, kita susah nak sampai kat situ balik. So after this, you guys yang kena sampai dekat situ, bukan saja setakat nombor 2 dunia, but you need to be the champion of the world. Okay guys, I can't wait to see you as our new mooters when you enter the Gombak campus later. I think that's all for me. Thank you. Assalamualaikum.
All right. Wow, such an interesting session with Brother Ashraf. Thank you so much, Brother Ashraf. There's so much tips that we got actually. So now we know that the IRAC method that we learned can actually be applied in Mooting as well, because it can develop our research skills, improve our written submission for Mooting. Also, we need to utilize LexisNexis as much as we can. And we have to remember that Mooting is different from debate because we need to play with sentiment and not just to prove our opponent is wrong, right? So inshallah, let us all join Mooting in the future. Okay, so now I know everyone is not tired yet, right? But why don't we take a short break? We will begin our next slot in 5 minutes. So in the meantime, if you have any questions, you may put them in the chat box and we will be back after 5 minutes, everyone. Thank you. All right, welcome back, everyone. So, everyone, before we begin with the last slot, let me first introduce our amazing speaker. He is Brother Muhammad Khairil Anwar bin Muhammad. So, as for this last slot, he will make a sharing about the client's consultation. So, without wasting any much time, I will now invite Brother Khairil Anwar to share this interesting topic. Please welcome. Brother Khairil, are you ready? I think we cannot hear you. Yeah, your mic is not muted, but we cannot hear you, unfortunately.
Okay, hello. Can you
Okay,
hear
now
me?
yes, we can hear you now.
Hello?
Yes? Yes, we can hear you now. Uh, unfortunately, we cannot hear you. Just now the audio is okay, but now it's not.
Miss Moderator, can you hear me right now?
Okay, now yes, we can hear
Okay,
you.
so I will not use my earphone lah, like that. So okay, let me introduce myself. My name is Muhammad Khairil Anwar bin Muhammad. I'm second semester student, and I'm doing my minor in applied finance. So about client consultation, let me just give a brief introduction about myself, how I get involved in client consultation. So my first involvement in client consultation started when I joined the internal competition organized by the IIUM Moots and Client Consultation Club last year. It was the Ahmad Ibrahim Advocacy Competition, AIAC. This is an internal competition whereby it has both client consultation and mooting competition. And the area of law was family law. And Brother Ashraf Hakimi was my coach for mooting. And because of his guidance, actually, I have won the best written submission for the mooting competition. But I don't want to talk about that because I will be brief, giving you talk on client consultation only. So let me share my screen first. Advanced sharing option. Share screen. Sorry. Okay. Can you see my screen right now?
Yes, we can. Yeah.
Okay. So let me start with what is client consultation. Okay. Client consultation is actually the very first step in advocacy. When Brother Ashraf Hakimi talked about the written submission, the memorial writing, and Sister Shamina have talked about arbitration or moot court setting. So before you go further to that step, the very first step is to actually meet your client. So you have to know what is your client want to bring to the court, and it is not compulsory for you to bring that matter to court because there is always an outside court settlement. You can just negotiate with that, but with the opponent of your client. But your client is coming to you to seek for legal advice, and this is the very first step of advocacy, because before you proceed to any legal action, you must first know who are the parties, what area of law that your client involved in, and what is actually his or her expectation from all those matter that he brings to you, to your office. So that is what client consultation is. And when it comes to the client consultation competition, the competition simulates a law office, and the law students or the student council are evaluated according to specific criteria. There will be criteria that I will be talking towards the end of the session later. And basically the criteria are in around, first is communication skill, how you communicate with your clients, that is first. And of course, because this is a law student competition, knowledge of law is very important. So you cannot just meet your client, but you have no idea about what area of law that you should be advising on to your client. And usually in the competition, they will provide you with what we call it, a thema to that competition. For example, in the previous internal competition that I have joined, the area of law was family law, and it's specifically on LRA lah, family law, LRA. It actually, family law is very wide, but the competition itself only talk about LRA on divorce, marriage, and nafkah, or maintenance of the wife. So when the organizer give you the area of law, basically this area of law will be given weeks or months before the competition started, and then they will be providing you with a short memo. Unlike mooting or arbitration competition, the organizer will provide you with very lengthy facts that you have to discuss on your written and oral submission. But in CC competition, there are no facts given in writing prior to the competition. All the facts will be given there and then on the day of the competition when you actually meet your client. So when you meet your client, that's it. You have to know what is the fact, and you have to really probe to your client's issue there and then. That's what makes CC different than mooting lah, basically, because mooting, you get the issues, you get all the legal issues before the competition, but CC, the legal issues, you have to find the issue yourself on the day of the competition when you meet the client. So on stages of the session, first of all, we have the formalities. Then we have the probing session. Probing is where you gather all the facts, and then you have to summarize the facts given by your client, and you have to give preliminary legal advice. So moving on. Formalities. Why formalities is important? Kenapa formalities ni penting? First is to build trust. Build trust ni is actually to make sure that you can control your client, because client, during the day of the competition, the client are not real client, of course. The client are the organizer, the committee that the organizer has provided with facts, and the client must memorize all the facts, so that kadang-kadang klien yang komiti yang jadi klien ni dia macam terburu-buru nak muntahkan semua benda. Dalam awal-awal tu dia terus cakap, okay, I ada ni. Macam you as the council, you akan rasa overwhelmed with all the information given terus macam tu. So the first thing, you as the council, you have to actually control your client. Sebab session ni is your session, and the client comes to you to give you his issue. So you cannot just let your client, okay, dia cerita je. Kadang-kadang apa yang dia cerita tu, it's not really material. So you have to control your client so that apa yang dia cakap tu apa yang dia cakap tu really contribute to your when you want to summarize and give your preliminary legal advice later. And on client control juga, you cannot like macam biarkan client tu pijak you as counsel. It's true that you have to be nice, but not to that level that contoh yang datang klien tu nanti dia akan macam-macam rank. Ada Datuk Seri boleh datang ke, Datin ke kan. Then the first thing you have to do is to address them according to what they prefer to be addressed. That's first. But no matter what rank they possess, you cannot put yourself below their level, which means you cannot let them be your superior in that session. You kena macam sama lah. Okay, client ni you respect him as client, but at the same time you must know your position as counsel, because kalau you dah lose that position, kalau you dah lose that control, your client boleh drive you into anything. Contoh dia macam dia boleh cerita something yang false, kan you cannot trust your client fully. You cannot fully trust your client. So when you let the client control you, then the client will cakap lah, okay, I nak macam ni, I tak kisah apa my legal position right now, I want this to be done. So macam tu dia macam letak you as inferior, padahal that your session. And it will not make you a good counsel if the client started to control you. Faham tak? Okay. Second is to improve productivity. Kenapa formalities ni penting? So that towards the session, sebab session ni dia limited to only in the competition lah. In the competition, it is only limited to 45 minutes. So if you dah lose control, your 45 minutes tu will be wasted lah. They will be you will be missing many relevant and important facts. And bila you dah miss out banyak facts, kita takut yang you sebenarnya tak boleh nak establish what was the issue, what is the issue right now. For example, in kita ambil satu area of law, contract law. Korang dah belajar contract tak dekat CFS? Okay dah. Okay, what are the elements of contract? Okay, tak apalah. Offer, acceptance, consideration. So, bila you tahu the competition is around area of law of contract law, so these 3 points are very important for you to establish first. Whether there was offer, acceptance, and what was the consideration. Kalau benda ni you dah tak boleh nak establish, so your legal advice, kita takut macam sebenarnya tak ada contract pun. Tiba-tiba you bagi legal advice as if there was contract. So dekat situ mistake of law dah jadi happen. When there is mistake of law, your marks will be reduced lah. Bukan reduce lah, your mark memang kena deduct lah kalau dah ada mistake of law kat situ. So that's why formalities is important lah. And next is to lessen misunderstanding. So lessen misunderstanding and address conflict of interest. So nanti dekat formalities tu, you have to actually explain on conflict of interest. Because, okay, contoh kalau you have represented a client which happen to be the opponent of your current client right now dekat depan you. So you sebenarnya tak boleh nak tak boleh nak represent lah sebab akan ada conflict of interest kat situ. So you have to mention this dekat the very earlier lah, very early. Sebab can you just imagine if the session dah go through like 20 or 25 minutes, suddenly you macam, oh, rupa-rupanya ada conflict of interest. Lepas tu you have to stop the session immediately kan. Then you cakap dekat client you, okay, sebenarnya kita nampak conflict of interest kat sini and we have to stop the session. What will be your client's mind masa tu? Dia dah spend 25 minutes stating all the facts, then suddenly you have to stop him. So macam Itu very waste of time. Lepas tu you kena cakap dekat dia, you have to find another firm yang tak ada conflict of interest. So kesian dekat klien tu and kesian dekat you, sebab time is the most valuable resource kan. After you dah cakap 25 minutes tu baru you nak berhenti, so that's not prudent lah. And benda ni sebenarnya happen tau in CC competition, international punya competition. The area of law was family law. Yang datang tu husband and wife. Husband and wife both are the parties to that issue. So the council kena pick seorang je lah to retain as the client. Yang seorang lagi tu kena tu. Then it's also a skill lah. You tak boleh just halau, okay sir, because there is conflict of interest, one of you have to go on to another firm. You cannot be like that lah. You kena cakap elok-elok. Okay sir, because this is family matter, then we have to actually do the session separately, and we cannot, when we have retained one of you, we cannot retain the other one. So you memang kena cakap elok-elok lah, so that the client faham and the client will understand you lah. And the client takkan lash out dekat you, oh you tak nak duit I ke, I bayar mahal ni. Ada je klien yang macam tu. Tapi kita lawyer, of course lah, kita kerja untuk dapatkan untuk menyara kehidupan kan. Tapi kita juga ada kita punya etiquette as a lawyer, and the ethics of being a legal counsel is dah stipulated under the legal Profession Act. Nanti if you want to join the CC, we will actually ask you to read some of the provisions relating to advocates and solicitors ethic dekat LPA. And last but not least, on formalities is confidentiality, because this is important sebab ada klien, for example dalam criminal law, jangan ambil criminal law lah, susah sangat. Kita ambil simple lah, contract, commercial, corporate law lah kan. Diorang ni kadang-kadang the client yang datang dekat you tu bukan on personal capacity. Kadang-kadang diorang datang on professional capacity. For example, someone from Petronas datang, okay, this is the issues. Then dia juga kena jaga interest of his company kan. So benda-benda macam ni, dia macam benda-benda yang patut you keep secret lah kan. You cannot expose it to anyone. So nanti klien tu tanyalah, kalau I bagi tahu you, you tak bagi tahu orang lain kan. Of course kita tak akan bagi tahu lah, unless it is provided by the law. You are obliged by the law to actually disclose. Contoh kalau ada polis datang your firm nak geledah cari file, dan dia dah ada warrant dah pun, warrant nak search warrant tu kan, then kat situ you kena biar polis tu carilah. Tapi tu memang yang special cases lah. Tapi the general principle is whatever your client tells you in that session, it should be kept private and confidential, which means you cannot disclose any of those things to anyone. That is the general principle. So moving on to the next part of the session, which is probing. Okay, probing ni, this is the most important lah. Sebab whatever you want to give advice later, it really depends on what you have established during the probing session. So macam tadi brother Ashraf ada cerita pasal I right. So in client consultation, we use my right. Our coach used my right. She said the very important thing is, the first one is material facts. So dekat sini lah, on the probing session ni lah, you have to look under material facts, because when the client comes to you, they will be giving you all facts that they might have. Tapi adakah semua fakta tu material? So macam mana nak decide whether the facts are material or not? Depends on your area of law lah in that competition. For example, contract law. The material facts is whether there is an offer, acceptance, and what was the consideration. Lepas tu, other material facts is, for example, in contractual issues, kenapa dia tak perform. Kenapa dia tak perform the contract pun boleh jadi material facts juga. Contoh kalau dia tak perform due to force majeure, ada tak clause on force majeure dalam contract tu, then you have to really probe lah. And tapi tu dah masuk details kan. Tapi the first thing in the probing session is we use open-ended question first. Sebab kita use funneling system. Funnel is macam, kalau you pernah nampak funnel kan, atas tu besar, bawah tu kecil. So makinlah mula-mula itu you ask very general questions. For example, the memo, dalam memo tu cakap Mr. Wajdi comes to call the office Mr. Wajdi called the office with a very angry voice, telling he has an issue with his contract. So that is the memo lah. Dalam competition tu memang macam tu je memo dia. 1 baris, 2 baris macam tu je. Tak ada facts lain. So you know dia ada issue dekat contract. So datang Mr. Wajdi tu, you tanya, okay Mr. Wajdi, based on the memo that we have received, this we see that you have an issue with your contract. Can you elaborate further on that? Then itu dah cukup open-ended lah tu. That is the very general question yang you boleh ask dekat dekat klien tu. And then nanti klien tu akan cerita lah. Klien tu akan cerita. Contohlah, okay, I mula-mula pergi kedai mamak, I jumpa Nurul Batrisha. Nurul Batrisha cakap dia nak jual dia punya Myvi harga 40,000. Tapi dia tak jual-jual pun sampai sekarang. I dah bayar deposit 20,000, lepas tu dia hilang. Lepas tu you kena ni lah. Lepas tu itu kan general kan. Lepas tu you have to probe lah. Okay, you have to probe. Masa you dekat kedai mamak tu, you kena tanyalah. Apa sebab you dah nampak kan, dia cakap Batrisha tu nak jual Myvi and dia dah bayar 20,000. So dekat situ dah ada offer, acceptance and consideration. Consideration dia apa? Myvi dibayar dengan 20,000 deposit dan akan bayar lagi duit yang lain sampai habis 40,000 tu dia bayar kan. So you dah establish kat situ. Then you kena probe further. You kena probe whether the offer and acceptance was valid. Offer and acceptance ada tak dia buat dalam writing. So you have to really look into that tu lah. Sebab dia akan bagi the general one je first, then you have to cari. Tapi ada juga yang klien dia muntahkan je terus. For example, dalam kita orang punya previous competition, when I represented IIUM as a reserve team, the host was University Malaya dalam bulan Mac hari tu. On the second preliminary round, klien tu dia muntahkan segala facts. Pam. Dia bagi tak henti-henti. Okay, mula-mula ni jadi. So kat situ US Council, you boleh catch up tak? Kalau dibagi contoh lah kan. Kita ambil contoh family issues. I cakap Melayu. Okay, I will try to speak English lah. I'm sorry. Sebab tengah hari kan. So ingat nak santai je. Okay. Wajdi cakap okay. 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 For example, in family law, the wife come nangis-nangis. Kan? The wife come nangis-nangis. Suami saya macam tu, saya jumpa dia dengan perempuan lain dekat Starbucks tengah minum. Padahal colleague je pun kan. Cuma dia tak tahu kan. Lepas tu saya ikut dia pergi office, tengok dia meeting semua. Kan, nampak tak kat situ klien dia macam-macam dia akan bawa. Lepas tu dia cakap okey, lepas tu saya follow dia, dorang check in hotel semua, bla 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 bla. Lepas tu lama-lama you as counsel memanglah seronok dengan cerita tu, tapi it's very time consuming and dia macam dia akan it will drag the session very lengthy lah. So you macam yang I cakap tadi, you as counsel you have to control the client. The moment you lose your client, then it will be very difficult for you to actually first summarize on the summarizing part, because when the client dah bagi macam-macam, sometimes it will be very difficult for you to actually distinguish which one is material facts and which one is irrelevant at all. Tapi bila you dah train banyak kali, nanti you will know lah how to distinguish what is material facts and what is not material facts. And sometimes the facts is totally irrelevant pun to your advice, so you have to omit that. So okay, so this is probing, on probing, that funneling techniques tu yang I cakap tadi. First, you have to motivate your client to talk. Sebab client ni, it depends on the area of law lah. Kalau itu memang family issues, kalau dah dekat court tu pun dah menangis-nangis depan judge, depan gallery semua tu, dia menangis-nangis. You bayangkan kalau dia datang office macam mana kan, bila datang office tu lagilah, I rasa memang tempat tak terbuka tu memang lagi seronok lah kalau menangis. So you have to encourage your client to talk. You kena cakap, okay, kalau dia macam reluctant to talk, you have to macam encourage lah dia to talk. Okay, cakap, tak apa madam, you said how to speak out in English. Okay, I'm sorry madam, I could only imagine what you're feeling right now, but it is very important for us to understand what's the issue, what brings you here. Then eventually the client will speak out lah, what is in her heart or mind. So bila you dah dapat buat klien tu bercakap and dia cakap lah, then you have to probe kan, you have to probe. Firstly you cannot ask close-ended question. Close-ended question ni contohnya, you dah makan ke belum? So jawapannya yes or no. Nampak tak? So awal-awal tu memang tak boleh soalan macam tu. So the example yang I give just now is, Wajdi have an issue on his contract. So the first question is, can you elaborate further on that? Ataupun around those lines lah. So that bila you bagi open-ended questions tu, jawapan dia boleh jadi pelbagai. So that daripada jawapan tu, barulah you kecilkan scope tu. To apa ni? Towards the end tu, you dah boleh terus tanyalah on the apa ni? On the close-ended questions. Contoh close-ended question tadilah, dah makan ke belum kan? Lepas tu, bila you dah dapat facts tu, you have to summarize. So, before you summarize tu kan, you have to ask the client what is his expectation coming to your firm or to your office. Sebab kalau you tak tanya apa expectation dia, then your advice tu dia jadi macam-macam. And kadang-kadang you advise on something yang client you tak nak dengar pun. Contoh, klien ni cakap dia memang nak saman. So lepas tu you cerita apa ni, tak saman pun tak apa. Ya, memang boleh you bagi that as non-legal advice kan, tapi bila klien you cakap dia nak saman, then you punya advice tu kena based on that that one lah apa yang klien you nak. Contoh dia cakap dia nak saman, then you kena advise boleh ke on the legal position lah, apa material facts tu you kena relate. Contoh dia cakap dia nak saman sebab tak fulfill the contract, tapi at the same time contract tu tak establish pun dia punya offer and acceptance tu valid ke tak. So you punya advice kat situ akan jadi cloud lah, and kalau you salah bagi advice, mistake of law will happen lah. You tak boleh just goreng je masa session tu. You kena dengar betul-betul. Dekat sini listening skill memang perlu padu lah. It different than mooting, because mooting is your oratory skills. Your oratory skills is very important. In CC pun sama, oratory skill, communication skill is vital. And the another skill yang you kena ada is listening skill. Sebab klien tu akan bercakap, and you have to write it down, everything that is material to establish your case. And macam yang cakap tadi kan, material tu masa klien tu bercakap, you tak boleh ada assumption tau. You cannot assume what is the legal issue. Contoh, you nampak ada case cerai. So you assume yang dia cerai on IBM, irretrievably broken down of marriage. Padahal IBM tu tak establish pun. So underground of IBM ni, dia ada pecahan dia kan. Sama ada unreasonable to live together ke, ataupun separation. So dekat situ you cannot assume okay under which ground dia nak cerai. So you cannot assume. You must ask the client what actually happened. The moment you assume, then your punya line of questioning tu akan berterabur lah, sebab you macam aku nak ni juga yang jadi, aku tak nak benda lain. So tak boleh lah macam tu. Let the client tells you his story. Then because that is your job lah, to listen and to give advice. You are not the one who narrate his story lah. So moving on summarizing. When you want to summarize, first, klien ni bila dia bercakap tadi on the probing session, the session will not necessarily be as smooth as we want, because kadang-kadang klien tu datang menangis, lepas tu dia cerita, mula-mula dia cerita pasal hari semalam, tiba-tiba dia cerita pasal hari 3 minggu lepas, tiba-tiba dia cerita pasal hari 2 minggu lepas. So you have to structure what your client's concern, and masa dia bagi fakta tu kadang-kadang ada yang irrelevant to establish the case kan. So you have to omit all the irrelevant facts, and you have to lay down material facts. Sebab kita guna MyRec kan, material facts, issues, rules, analysis or application, then you conclude lah. And when you want to summarize, it can be based on the chronological order. Chronological order tu macam okay, dari klien tu cerita okay 3 minggu lepas ini jadi okay tu, then you have to summarize lah. Kadang-kadang klien tu tak bagi on chronological order pun, cuma you yang kena buat chronological order tu. Ataupun if you don't want to give on chronological order, you give on probable course of action. Contoh dalam case negligent, duty of care, you ceritalah dari negligence kan, negligence is course of action, then you have to cerita satu-satu lah daripada duty of care, proximity, breach of duty, semua tu. That's how you want to summarize lah the facts. And then preliminary legal advice. So you have to really put this in your mind now. When the client comes in this competition, it is his very first session with you, which means they may be sesi yang seterusnya lah. So whatever advice that you give on that moment, it shall not be conclusive. You must address this to your client lah. And sometimes client tu akan tanya, kenapa tak konklusif? Buat apa I datang jumpa you? Then you have to macam, you kena cakap lah dekat dia elok-elok. Cakap elok-elok yang, okay, madam, since this is your first session with us, and contoh dia datang sebab contractual issues. So, tapi masa dia datang tu dia tak bawa dia punya contract. So, you cuma bagi preliminary legal advice, then you cakap, this is just a preliminary legal advice. It's not conclusive. We have to look further into your contract. And itulah. Kalau dia dah dapat saman daripada, contoh kalau your client is a defendant and dia dah receive writ of summon from the another party kan, your advice pun tak boleh jadi konklusif juga, sebab summon tu you have to read what is the cause of action yang the plaintiff brought against your client. You have to first understand, and itulah. Tapi for the sake of competition, masa advice tu, you just advise on what your client have give to you. So you don't assume too much lah. Apa yang ada tu bagi. Macam yang Imam Syafi'i pesan lah. Nahnu nahkum bi zawahir. Kita berhukum dengan apa yang zahir je. Yang tak zahir tu, fatawakkaltu ala Allah. Okay, tapi tak boleh lah tawakal itulah dalam session ni. You kena betul-betul fikir lah cause of action apa, the material facts tu you memang kena fikir betul-betul. And then when you are giving advice to your client, you should avoid using too much legal jargons, or even if you use legal jargons, you have to give macam brief interpretation lah, ataupun definition to your client, so that your client understand what actually you are talking about. Because in this competition, it's not like mooting, it's not like arbitration. You are addressing to your client, you are addressing the issue yang your client bawa. Kalau dalam mooting or arbitration, macam Mina and Ashraf presented just now, you are addressing the judge or the arbitrator, and they are experts in law. So kalau you sebut macam-macam causa sine qua non ke apa, actus non facerium bla bla bla, tu pun dorang boleh faham lah. Tapi kalau you cakap dekat your client and you just use simple word kan, force majeure, apa tu force majeure? So you have to define lah. Force majeure is unforeseeable circumstances which prevent the party to the contract to fulfill his obligation. You bagi definition yang boleh difahami itulah. You janganlah define apa ni force majeure ke apa-apa legal jargon ikut kamus, sebab kadang-kadang kamus ni pun boleh confusing juga. So you have to actually ada your own words to interpret whatever legal jargons to your client. For example, force majeure kan tadi, kalau you refer to dictionary, force majeure is defined as superior strength kan. How can you relate superior strength to contract or to the issues that your client ada? So you have to tailor-made lah. Whatever yang you say to your client, you have to tailor-made it according to his profession ke, apa-apa ke, background hidup dia ke. Kalau your client is a lawyer, tak apalah. Mungkin dia boleh faham lah. He should know lah sebab dia lawyer. Tapi kalau your client is a layman, macam contoh pemain bola ke, ataupun orang-orang yang start study law, then you have to make sure that he really understand. As a layman, he really understand what you are saying, because your job as an advocate is to advocate the law to layman, which means whatever comes from your mouth can be understood by a person in his position lah. So that is all on the stages of CC. So let us look into the format of the competition. So the competition, like I said just now, simulates a law office consultation. So dalam competition tu, you akan duduk dekat satu meja with your co-counsel. There will be two students, two student counsel, and there will be one, usually one client lah. You will be sitting on the table, then the client will come to you, okay. And you can act as a counsel lah. You cannot act like a student. You can act as a counsel yang betul-betul nak bagi advice to him. And the client will come and you can start lah the session. Usually kita start dengan the session with macam small talks ke. Later I will show you a video lah on simulation of how CC works. And then the team setup, usually we will dalam satu team tu kita akan ada 4 member, 2 legal counsel, 2 researchers. Research pun important, not only in mooting or arbitration. In CC, research is also important, because like I said just now, the organizing committee or the organizer of the competition will be giving you a team for you to work on, to research further. And the team ni memang general je lah. For example, in the previous competition, dia cuma bagi contractual issues on sport and entertainment law. That's it. For next year punya competition, the team is environmental law. The team dah keluar dah pun. Kalau mana nak tengok team ni, you can search on ICCC, Brown Mostyn ICCC. Brown Mostyn is an international punya level lah for CC. And CC memang tak banyak competition pun. In national round, kita cuma ada satu, Piala Tan Sri Harun M. Hashim, National Client Consultation. And whoever win that competition will represent Malaysia to the international level, ICCC, Brown Mostyn ICCC. So whatever, biasanya lah, whatever the international team is, the national round will follow the international team lah. So ada 2 legal counsel, 2 research members. Research members ni memang will be playing very vital part lah on research, because kalau kita nak harapkan yang 2 main team ni untuk research, macam it will be burdensome lah to them. So they need someone yang conduct research juga. Tapi bukannya research team ni aja yang conduct research. The council will also conduct research, but the research members ni yang akan bagi betul-betul effort on research lah. The research skill tu macam yang korang dah belajar lah on your library skill, and later in your first year, second sem, you will be learning legal method. Legal method, laws 1030. So if you want to join the CC team, your legal method memang kena betul-betul power lah. Bukan CC je lah, mooting ke pun, jangan tidur kelas legal method. That's very important class lah, you have to listen. Okay. And who will be the client? The client ni, the AJK lah, the committee, the organizing committee. And usually they will ask law student lah to be the committee, because yeah, I don't know, maybe because only law student understand law student, but that is the practice in the competition, whereby the organizer will ask students to be the client, and itulah, the client tu dia akan diberi satu hypothetical issues, and the client will memorize. So bila memorize ni, kadang-kadang dorang gelabah masuk session. Kadang-kadang counsel tu okay je, client yang gelabah. So bila your client tu gelabah, you have to control lah. Macam yang cakap tadi, client control is very important. Okay. And how the judges will assess you as counsel in that too. So first and foremost, because we are human kan, kita ada preference. So judges tu dia memang akan ikut preference lah on how to conduct session. Tapi yang ni I rasa dah tak ada kot sekarang sebab kita memang preference tu preference juga, tapi kita dah ada rubric, so the judge must follow suit lah the rubric. So the next criterion is your ability, the student council ability to explain the word in simple language. Because it's not like mooting or arbitration yang mana you boleh use all those fancy English, law English punya sentence construct kan. Tapi dalam sisi ni, your punya sentence construction tu must be tailor-made lah to whom you are addressing the issue. Kalau dia ni pemain bola, then you have to address it to a pemain bola lah. Kalau your client is a lawyer, you have to address it to a lawyer lah. Macam you address the issue to a lawyer. And then the comfort level between the lawyer and client. So this is where the formalities to play very important role lah. Because kalau formalities tu you dah slack, then towards the end of the session ke ataupun as the session proceed, you will feel that awkward moment tau dengan klien. Padahal klien tu manusia juga kan, dia datang dia bawa masalah, then you settle lah. You bukan settle dia punya masalah, you bagi advice how to settle his problem. And you kena ada comfort level tu. It's not to the level where your professionalism to cloud. You must maintain your professionalism, but also you cannot be too awkward or macam batu, macam tu lah. Even kalau you jumpa judge dekat mahkamah sekalipun, you takkan layan the judge macam someone yang tak ada feeling. You kena ada comfort level juga dengan judge tu. Same as to your client lah. Moreover, when you will be working with, bukan working lah, you will be working for your client, with your client. You will be working on understanding what is the issue, gathering evidences. The client, you kena nanti, this is not in the competition lah, of course, this is in real life, where your client tu, you akan terus contact your client kan, sampailah case tu habis. So comfort level tu kena ada lah. And comfort level ni macam ni you nak tahu you dah you dah success or not, it depends on the client lah. Kalau contoh kan, awal-awal dia address herself as Datin, tiba-tiba you panggil Datin, dia cakap tak apalah, panggil akak je. Then you know your place lah. Maksudnya you dah tahu yang the client is very comfort with you. Tapi kalau memang client tu jenis yang dia nak maintain professionalism dia tu, it does not necessarily means yang dia tak comfort with you. Comfort ni you kena experience it lah. It cannot be expressed by mere words. You have to experience it by yourself. And the satisfaction of the client lah. Towards the end of the session nanti, not towards the end lah, after the session ends, the client will stay with the judges. Then the judges will ask whether the client satisfied or not. Kalau client tu tak satisfied, then ada markah juga dekat situ. For example, kalau your client has one issue kan, tapi you tak address dia punya issue tu, so the client satisfaction will be very low lah, sebab you tak address his issue. So that's where probing tu very important. Probing and your legal advice very important. Probing ni that is the longest part of the session lah usually. Biasanya formalities ni we set around 7 minutes of the session je. Tak panjang-panjang pun. Nanti you will look into the simulation lah. I will show you the simulation. So the probing part ni, ini yang paling panjang sebab kadang-kadang dalam competition ni, bukan kadang-kadang lah, usually dalam competition ni paling banyak pun dia akan bagi 2 isu je. Dia takkan bagi banyak-banyak sangat sebab dia tahu 45 minutes is not enough lah to address more than 3 issues. Tapi kalau dalam 45 minutes ni, you tak boleh nak bagi your client satisfied with that session, then your marks for the competition will be very low. Okay, so I think that is all. So these are some photos of our previous teams. In the left one, this is our team. We won the national level and we represented Malaysia to Puerto Rico in 2014. So kalau you menang, kalau you dapat wakil UIA and then you menang, you will go lah to this international competition. And it is fully sponsored by the university, which means you tak keluar duit lah nak beli tiket tu. You dapat pergi representing IIUM, not ICOL only, but the IIUM. And on the right side, and this is our team, won national competition and they went to Windsor, Canada. And this is our team in 2018 competition in UKM. If I'm not mistaken, we were the semi-finalists, if I'm not mistaken. This is our team in UNIZA in 2019. So if you see right here, this is Hashima and Christina. Hashima is currently 4th year 2nd sem student. She'll be graduating in 2 or 3 weeks time. And Christina graduated class of 2020. And Christina still coaching the team right now. Same with Shima, but Shima is currently, because she's 4th year student, so tapi she's very good. Both of them are very good coach. So kalau you not join us, and if you join us, you will see those faces lah. We are very nice to each other, don't worry lah. And this is 2020 competition. Shima also here. She was helping the team for research. And these are the research team. Ainun, Fatini. Ainun is currently 4th year 1st sem student. So later next sem, kalau you masuk ICOL, you masih boleh nampak Ainun lah. Fatini will be graduating. This is Kausa. In 2020, kita orang pun dapat semi-finalist kot in UITM, if I'm not mistaken. Okay, so I think that's all. So before I end my submission, before I end my presentation, macam mana nak tutup? Oh, stop share. Tak stop share. Okay. Okay. Okay, can you see my screen?
Yes, we can see your screen.
Boleh nampak tak? Okay, boleh dengar?
Boleh.
Boleh Boleh. Okay, this is the demo lah. Nampak tak?
Are you sharing a video?
If she has some problems with her neighbor. I think she's outside. I'm going to go first.
We cannot see the screen, but I can hear the audio.
Oh, ya ke? Macam mana Pandai lah. Sekejap. Oh, tak ada full screen kot. Kalau macam ni, cukup besar tak?
Sure, I'm supposed.
I think the screen is not moving.
Oh, ya ke? Tak apalah kalau macam tu. I will send the simulation video. Nanti you can always watch it lah. Nanti the organizing committee will be sharing the apa ni? Itulah. So I will stop share my screen. So I think that is all for my talk today. Thank you. Wait. I nak promote something on CC sebab Ashraf dah promote CC kan. So I nak promote Ashraf dah promote Mooting, I nak promote CC lah. Okay, macam yang I cakap tadi kan, IIUM ni dikenali sebab Mooting tu kan. IIUM juga dikenali sebab dia punya CC. And kalau korang tengok tadi my presentation, we represented Malaysia for many times. Okay, Puerto Rico 2014, Canada, and before that pun ada juga. Before 2014 ni pun ada juga, cuma tak masuk dalam slide. Yang memang lama-lama punya lah. So kalau you macam, yeah, of course we are attending the training session to learn, right? But kalau you dapat menang tu dia rasa lagi puas. And right now we are in our training session. I don't know bila korang masuk iCall, but I will always open the team recruitment lah for first year student nanti after when you come to iCall. And the Mooting Club also will be organizing internal competition, and we are planning to do that. So insyaAllah dalam internal competition tu akan ada CC juga. So you kalau you betul-betul berminat, and this is not for the sake of representing IIUM ataupun menang itu ini, pergi keluar negara, whatnot, but all the skills that you learn in that training session, you will use it when you are practicing as legal counsel, or even if you are not practicing pun, the communication skill, oratory skill, public speaking, research, analytical skill yang you belajar towards sepanjang throughout the training session tu, you will use it for the rest of your life lah sampai you retire. So that's the importance of joining our club, particularly on CC, because we are training you not to be a counsel per se. We are training you to be a human, because we are communicating not only to legal counsel or other advocates and solicitors or to the judges. We are training you to address your client's issue. Sometimes kalau you dapat klien ni, diorang bukan kisah sangat pun pasal you punya legal jargon, legal advice tu. Sometimes your client ni just want to have macam talk yang ringan-ringan, bercakap kan. Ataupun kalau bukan klien pun, the skills yang you learn masa CC ni, it will very helpful masa you nak bagi advice ataupun you nak bercakap dengan siapa pun. Contoh advice yang paling simple you boleh bagi is to your friends kan. Kawan tanya nak makan mana, then you advise, okay, student center ada apa, Zarawi tak ada cafe, Biruni makan macam ni, kita pergi Azdah lah, Azdah ada shawarma. Tak tahulah Azdah ada shawarma lagi ke tak, tapi dulu masa I dekat Gambang ada lah shawarma tu dekat Azdah, sedap shawarma Azdah tu. So kalau you betul-betul nak train yourself, ada, bagus. Kalau you betul-betul nak train yourself as counsel kan, tak kisahlah you join Mooting or CC. Masa you join the training later, when you come to iCall, you have to put mindset you are here to learn, not to compete or to participate in competition. That's the second thing lah. But the very first thing is you are here to learn. So that bila you put your intention straight like that, no matter whether you can represent IIUM or not, you will always respect each other, and you will always try to improve yourself. Tak ada habis competition tu habis. Tak ada. Dia habis competition ke, tak habis competition ke, you still improve yourself in your own ways lah. So that's what we are trying to do in IIUM Moots and Client Consultation Competition. Okay, I think that is all from me. Thank you. I pass back to the Miss Moderator.
All right. Thank you so much, Brother Khairul Anwar, for the interesting yet informative sharing just now. So after this, we have to remember that we really need to understand the law in order to do the client consultation. Also, research is very important as well. And I hope that all of the tips given by Brother Khairul Anwar can be applied once we have client consultation in the future. So now let's, since we have finished all of our slots, let us move to the Q&A session. So I can see that we have some questions listed in the chat box. Inshallah, the speakers will answer all of them. So we're going to start off with the very first question from the committee, from Adriana Kistina. So before that, are all the speakers ready to answer the questions?
Yeah, I'm ready.
So I think the first question is for Sister Mina. May the speakers enlighten us the technical parts on how long the preparation for a mooting competition would be and how long a mooting session is. So Sister Mina.
All right, thank you for the question. So in regards with the duration for a preparation for a mooting competition and also how long a mooting session is, I would say that it varies according to the type of competitions or mooting competition that you go for. So the shortest can be around 1 month, and we have KPUM, the one that I showed, KPUM at Sharing the Labor Mooting Competition. So that competition has a period of preparation for only 1 month before the actual competition. So that would be the shortest duration. And the longest duration would be the VIS. Usually the big competition will have a longer period for preparation. For VIS, we have like 7 months, starting from September up to April. That would be the preparation part for a mooting competition. It varies according to the competition that you're going for. And in regards with how long a mooting session, it also varies according to the type of competition. For example, if the LexMoot usually will have a 30-minute per session, and this 30 minutes will be utilized like 15 minutes for each speaker. So for example, if you are representing a claimant, so if you have 2 speakers, right, the procedural speaker and also the merit speaker. So the procedural speaker will utilize the 15 minutes first, and then followed by the merit speaker that will be utilized later 15 minutes. So that 15 minutes will also include the rebuttal session between these two, between the counsel for claimant and also counsel for respondent. That would be in regards with this. And there's also a competition where they allocate 45 minutes per session, like KPUM. So I would say that we don't have like a default preparation time and also mooting session time, but it will vary according to which competition, which types of competition you're going for. I hope that will answer your question. Thank you.
All right, so thank you so much, Sister Mina. So another question from the same committee. She just wanted to clarify that is arbitration means like a debate setting and mooting is like a trial court simulation. Can Sister Mina enlighten us with the...
Yes, sure. Actually, both arbitration and also mooting do not have anything to do with debate, although it might seem like it in the first glance. It's just that arbitration, all the counsels will be sitting down when they are submitting. And mooting, like a trial court simulation, it is all the counsels will, not all, when they are presenting their argument, they will be standing up. Meaning to say that mooting, yes, it is a trial court simulation, but arbitration is not a trial court simulation. It is outside of the court simulation because arbitration is a form of alternative dispute resolution. So when we're talking about alternative dispute resolution, it can consist of arbitration, mediation, negotiation. So this mooting is indeed a trial court simulation, but arbitration is not a debate setting. It is outside of the court settlement simulation. Yeah, that would be it.
All right, thank you so much, Sister Mina, for the answer. So I think for the third question, it is the same as the first question. So we're going to move on to the fourth question. I think this question is for Brother Ashraf. So when Brother Ashraf shows the submission in slot 2, I saw that the argument is quite difficult to be formed. Could you please explain what are the process and structure of a good argument in our submission? Brother Ashraf?
All right, thank you very much. So I will answer on the question of the process of developing argument now. Okay, how to develop argument? The first step is by doing your research. You start everything by your research. Okay, first one is research. Why you need to start with research? Because by doing research, you can understand the law. Okay, you need to find what law is applicable, what the area of law of the dispute. Okay, first research. Second, after you've done your research, okay, now you have know what is the area of law that is involved. Then you need to find what are the statutes that is applicable into our current case. Are we using Consumer Protection Act, Contract Act, CISD, and so on? That's the second step, which is we need to know what are the statutes applicable in our current case. The third step is, after we know the statutes, then we need to identify which provision is the most suitable to be used in our case. Okay, which provision is the most suitable that we want to use in our case. And by here, you can develop your argument. For example, in the case of breach of contract. So you need to determine, you want to concede there is a breach committed by your client, but you relied on the defense of hardship, or you want to argue that there is no breach at all at the first place because our case has not fulfilled the element of breach of contract. Okay, so after you has determined which provision that you want to use, you move to the next step, which is find the most suitable case that you want to submit to the court. Okay, find the most suitable case. And lastly, you apply to our case, and then you make the conclusion. Okay, so that is the process of developing an argument. How to structure it? Okay, how to structure it? First, you start with your submission. Submission, under one submission, you can have one first argument, second argument, third argument. For example, first argument, you can say that in the case of breach of contract, you can say that at the first place, there is no breach committed by your client. And then you give provision, you give case, and then you explain why. Settle first argument. Coming on to the second argument, you can say that even if there is a breach committed by your client can rely on the defense of hardship. And then you give the provision, the case, and application. And then you make a conclusion that you submit to the court that your client has not breached the contract. And even if there is a breach of contract, your client can rely on the defense of hardship. So basically, that is the process of how developing an argument and how to structure it. Basically, it's just an IRAC, but you can be creative with it. Thank you.
All right, thank you so much, Brother Ashraf, for the explanation. So for the next question, I think this question is for Brother Khairil Anwar. The question is, Brother Khairil said that we must look deeper in order to establish questions, right? So based on your experience, how do you guys practice, or what are suitable mechanisms to have a really great questioning skill? So Brother Khairil, can you please enlighten us?
Okay. All right, thank you, moderator, and thank you, Farina Adini, for asking the question. Based on our experience, how to actually construct the question is, first, like Brother Ashraf said, research. In every law student competition, research is very important, so that you know what to establish. When you don't know what to establish, you don't know what to ask. That's the very vital one. And when you conduct research, research does not mean reading lecture notes or textbook or whatever in the LexisNexis only. In CC, research is, we also research on the practical part of that law, because everything in that textbook or online database, it's all theoretical. So you have to deal with the practical part also. For example, on force majeure, you know, if force majeure happens, the contract may be frustrated, but what if in that contract there is a frustration or apa ni, force majeure clause. Usually force majeure clause ni dia akan cakap if any of the party is prevented from fulfilling his obligation and duty under this contract, the contract will be apa, dia cakap lah contract tu mungkin apa ni, the party will be excused from fulfilling his duty until he can to, that's force majeure clause lah. Ataupun kalau ada dia cakap terus contract tu frustrated ke apa, it depends lah on the contract. Okay, so that bila you nak buat line of questioning tu, you must know your apa ni, area of law tu. Bila you dah tahu area of law tu, you ask first the very general question, and from that very general questions tu, you tengok your client tu stop dekat mana. That's to show that we are attentive to whatever he speak lah. Tak adalah kita ni shock sendiri kan dalam session tu. So contoh macam klien tu cerita dia pergi kedai mamak buat kontrak dengan Farina Adini, and then dah lepas tu dia cakap dia buat kontrak dengan Farina Adini. Contoh that's the last sentence. So you ask lah, what was the contract about? So dia akan cakap lah what was the contract about. So the line of questioning is, first you must know your risk, you must know your area of law. Second is communication skill lah, to address the client, to how to be attentive. So that bila you dah master dua ni, this is the simplest thing yang you have to master on lah. Baru you can construct the questions very well. Is that answering the question, Farina?
Farina?
Yes, brother. Thank you.
Okay, all right. Thank you.
All right, so thank you so much, Brother Karil, for the answer. So I think this is the last question from Aino Shazwina. She asked, what are the best approach to firstly make when the area of law for clients consultation competition or mooting are out of scope that we have learned from our syllabus at that time? So which of the speaker would like to answer this question? Maybe Sister Mina?
I'll pass the question to Ashraf Hakim.
Okay. Actually, Mina is the best person to answer the question, but I just share my experience. The first one is, the question is about, I want to read it again. Best approach to firstly make when the area of law for CC competition or mooting. Okay. First step that I did before was I asked my seniors. I show him this the moot problem and then the issues, and then I asked him, what are the relevant laws that I need to explore, and then I consult my lecturer, and then all the information that they say about, they talk about hardship, they talk about force majeure, they talk about conformity, they talk about the principle, yada yada yada, and then every single word that they say to Google it. After you Google, and then barulah you dapat the eagle view of that principle, and then you can start doing your research. Okay, so the answer to this question is, if you have no experience in that particular area of law, don't just start by yourself, but instead consult your lecturer and consult your senior, and every single word yang diorang cakap tu, which you don't understand, write it and Google it. Okay, that's my first advice. My second advice is, don't be afraid, because if you think that this is your first time of doing the research on private international law and so on, bear in mind that your opponent also has the same experience. Your opponent pun mesti tak akan pernah punya. And even if you thinking that, oh, my opponent at least diorang dah third and fourth year, still don't be afraid, because You need to understand, oh, I'm first year student, second year student, but I made research on this area of law, which prove that I've better than them. Fikir macam tu. Okay, that's all from me. Thank you.
All right, thank you so much, Brother Ashraf, for the answer. So Alhamdulillah, we have reached the end of our Q&A session. Thank you so much to the speakers for answering the questions. Now, attention to all students, you may now fill in the attendance link provided in the chat box. So before we end our session today, I'd like to express my gratitude and thank all of you for joining our event today. To the amazing speakers, thank you so much for receiving our invitation, and we also thank you for the beneficial input that you have shared with us. And not to forget all the committee members and lecturers in charge who worked really hard to realize this program. So may the students gain all the benefits from today's program, inshallah. So with that, I'll end our session today with Tasbih Kafara and Surah Al-As. Before that, everyone is required to stay in this meeting for a while, as we will be having a quick photography session. So if you can open up your camera, you are required to do so and use the background that we have provided. So our photographer, Sister Farina, are you ready?
Yes, I am. Everyone ready? Cheese. Freestyle. Okay then.
All right, thank you so much, everyone. You may now leave the session.
Thank you so much.
Thank you.